Allora, buongiorno a tutti, come presidente di Medel, l'associazione che promuove questo evento alla Dipartimento Democratica, all'Università Roma 3, la Fondazione.
The interpreters cannot hear properly, so we are waiting for better sound conditions. Thank you.
Ringraziare l'Università Roma 3 in maniera formale, Scalati in particolar modo per l'ospitalità e per aver sostenuto il nostro progetto di svolgere in questo luogo di cultura, di pluralismo, di confronto critico, il nostro dibattito.
Simultaneous interpretation is not yet available because of poor sound conditions. We are waiting for better quality. Thank you.
Desidero fare una apertura, un ringraziamento non formale anche in particolar modo a tutti quelli che hanno collaborato all'edizione di questo evento, ma in particolar modo a Sala per il suo indiscutibile contributo in tutte le fasi di ideazione e realizzazione di questo evento e diciamo per la gestione efficiente e competente, direi brillante anche di tutti gli aspetti organizzativi. Medel, Magistrato per la democrazia e libertà, associazione che rappresenta e che comprende oggi 25 associazioni di giudici e uffici di 17 Paesi membri del Consiglio d'Europa, ha tra i suoi obiettivi la tutela dei valori democratici dello Stato di diritto e dei diritti fondamentali delle persone. Medel è nata nel 1985, già allora con lo sguardo rivolto all'integrazione europea e per promuovere l'integrazione europea basata su questi valori comuni, Stato di diritto e diritti fondamentali delle persone. Sin dalla sua fondazione, Medel ha tra i suoi scopi statutari la promozione e una prospettiva di emancipazione sociale dei diritti fondamentali dei migranti e delle persone più vulnerabili. Nel progetto visionario dei nostri padri fondatori, l'immigrazione si presentava infatti già allora come una sfida decisiva per l'Europa Unita. Per quell'Europa Unita, come oggi la descrive il preambolo della sua Carta dei diritti fondamentali, un'unione, dice la Carta, sempre più stretta, nella quale i popoli europei hanno deciso di condividere un futuro di pace fondato sulla bene comune. Una unione che è consapevole del suo patrimonio spirituale e morale, pone a suo fondamento i valori di principio universali di dignità umana, di libertà, di uguaglianza e di solidarietà, i principi della democrazia e dello Stato di diritto. Un'unione che mette la persona al centro della sua azione e che si impegna a garantire il godimento dei diritti fondamentali, assumendo per questo responsabilità e doveri nei confronti della comunità umana e delle generazioni future. Cosa resta oggi di queste promesse? Nella sezione del Missing Migrants Project dell'ONU, l'Organizzazione Internazionale dei Migranti, che dal 2014 raccoglie dati e informazioni sui migranti morti e dispersi, leggiamo che nel 2024 sono stati 461 morti e dispersi solo nella rotta del Mediterraneo centrale, 2105 lo scorso anno. E in Europa, nel Mediterraneo centrale, la rotta migratoria più mortale al mondo. 23.220 persone sono morte dal 2014. Questi numeri danno conto di quanto pesante sia l'eredità che ci portiamo dietro e che è diventata un'ipoteca sul futuro dell'Europa e della sua democrazia. La sopravvivenza stessa del progetto dell'Unione Europea come comunità che mette al centro la persona e i suoi valori è oggi legata alla capacità dell'Europa di comprendere
con il fenomeno migratorio, un fenomeno, come ha scritto Luigi Ferraioli, costitutivo di un nuovo ordine mondiale, destinato quale istanza e veicolo dell'uguaglianza a rivoluzionare i rapporti fra gli uomini. Un fenomeno che richiede un cambiamento radicale della narrazione di ciò che l'immigrazione rappresenta, non una minaccia, non solo un'emergenza, ma un'opportunità. Oggi siamo a un bivio. Siamo al bivio dove ci hanno portato invece negli anni politiche nazionali, europee, non all'altezza di questa sfida. Un approccio di contenimento e di riduzione del danno, come quello che vuole la distinzione di status e di diritti fra profughi e cosiddetti migranti economici, sull'assunto che i primi sono forzati, spinti, obbligati a lasciare il loro paese, gli altri volontari e perciò liberi di scegliere. Sono schemi classificatori questi che hanno dimostrato nel tempo quello che sono, del tutto inadeguati. Pensiamo che prima del ritorno dei talebani in Afghanistan era considerato da paesi europei un paese pacificato, da altri paesi, fra cui l'Italia, se non sbaglio, concedevano la protezione internazionale. L'esperienza del nostro paese offre l'esempio dell'approccio da Fortezza Europa, che ha proposto la migrazione in termini di sicurezza e di ordine pubblico, con un ampio uso anche paese pacificato, da altri paesi, fra cui l'Italia, se non sbaglio, concedevano la protezione internazionale. L'esperienza
The experience in our country represents an example of the approach of Fortezza Europa, so as a European fortress, which promoted an approach for security and the interpreters cannot, okay, by introducing specific crimes, by relying on the instrument of administrative protection in an emergency logic, which introduces new forms of freedom limitation. The interpreters cannot translate entirely the content because the sound comes and goes. Today, we are facing an emerging model, which is a declining model when it deals with regulating migration, considering the UK government choices, considering the recent choices or the refusal of the Belgian government to implement some regulations and provisions for the protection of asylum seekers. Let's think about a new migration law in France. Today, we are at the crossroads between choices, and we have a moral and ethical regression of Europe in terms of boundaries. In 2016, we had an agreement with Turkey. Europe made an agreement with the Turkish president on the Balkan route. We saw then what happened, but what is happening today has shown that we are facing another paradigm change. A new threshold has been crossed, and we are using violence for control and surveillance of frontiers. In February 2022, the UNHCR made some interviews on violence, refusals, and our episodes that were reported at the frontiers within and outside the European Union, with just a few exceptions. The European countries have not made any investigations, but walls have been built at the frontiers. We are following this direction. We are now supporting third countries in order to guarantee the control and the admission of migrants. So Europe has redesigned the support policies for migrants, not considering the main goal of international cooperation, considering the development and humanitarian support. The goal is to eliminate, to cancel, to remove poverty based on the European Union Treaty. In 2020, a report that was asked for by the European Parliament stressed how this external migration policy of the European Union shows a lack of appreciation and of the importance of the European acquis in agreement with countries where there are no guarantees, no rule of law, no protection of fundamental rights. A memorandum of understanding was signed with the Sudan president by the European Union. The same is true for Libya. We also have agreements, the EU also has agreements with Tunisia, and some worries were raised on the situation, and all relations with third countries based on the report are based on statements and multilateral and bilateral protocols. The financial support of the European Union has also not abided by the provisions of the European Parliament. In terms of demonization, criminalization of migrants, it has become a local phenomenon. Here, I would like to quote the High Commissioner for Human Rights for the EU in 2021. She said that the NGOs are not recognized in their key approach. Here we are in Italy with some security decrees in 2018, 2019. There was a policy of closed doors at the boundaries, closed harbors, and today the employees of the public department, but also institutions, have raised concerns of the civil society. A new code was introduced for the NGOs in January 2023, and the result, and there was a concern that the result could not allow international and humanitarian organizations to operate and be effective. Here, the High Commissioner for Human Rights stressed some concerns, expressed some concerns, and the same is true for experts who did the same, experts of the NGOs. It raised some concerns, the Council of Europe raised some concerns about this fundamental right. The goal is always to protect the fundamental rights of people. It is the interpreters cannot translate entirely because of interruptions of sound. The primary rules should be applied and implemented, as well as the main principles. Ben compreso che oggi questo significa anche rischi per la tenuta del sistema di tutela sovranazionale fondato no sound available dei diritti dell'uomo e sul ruolo della Corte di Strasburgo. Anche qui penso today alle scelte su Ruanda del governo. We see also the guarantee role. Abbiamo ben compreso che oggi questo significa anche rischi per la tenuta del sistema di tutela sovranazionale fondato sulla Convenzione. Non è un caso che in Francia, anche in Italia, sui migranti, e l'accusa di parzialità, il nuovo tema utilizzato per mettere in discussione la legislazione per le decisioni che non sono considerate in linea. There are new decisions in case law that are not in line with the governmental policies, and associations are also involved with these topics in France and in Italy. There are some partiality accusations. as well as the legitimation of decisions, as well as the right of judges to participate in public debate. So this is the main topic today, and representing the public opinion. Judges, with their decisions, are not in line with political decisions, and all of this causes the lack of success of governmental strategies for migration. I would like to draw to the conclusions by highlighting the importance of the new European Pact on migration. Over the last few months, we have seen a faster approval approach. We have already heard voices from the civil society and from universities, from institutions and law experts about the changes of this pact, of this agreement, in terms of possible consequences on the fundamental rights of people. Today, I would like only to quote a letter from 2023 from the Special Rapporteur on Human Rights. These concerns were expressed by this letter. So there is a fake legal provision of the non-entrance that considers these people as non-able and non-authorized to enter the territory of the EU member states, even though they are physically there. I would like to also add a new paradigm of instrumentalization of migrants, which has become a legal concept. We have seen what has happened over the last few years when talking about instrumentalization of migrants. The EU member states felt the legitimacy to deny the asylum right, the right of asylum, and the governments that were against migration wanted to put pressure on the other member states of the EU. So this concept, this idea was used to support these practices and procedures of repatriation against migrants. So, thanks to the legal experts, we are now working on fixing these issues, considering the fundamental rights enshrined in the Covenant, and also the rights that are enshrined in the different national constitutions. We need to be aware of what is happening when facing these topics, when dealing with these topics as legal experts, but also as citizens, because in not many fields such as this, we should be aware of what is happening, and we need to be in line and to abide by the concerns of equality, against fear, against inequalities, which is the danger that now Europe and all of us are facing. Thank you.
L'altro ieri approvato dal Parlamento europeo a stretta maggioranza.
Now we will have from remote a speech by the President of the Commission of LIBE, so the Committee on Civil Liberties, Justice and Home Affairs of the European Parliament, Juan Fernando López Aguilar. Greetings from Brussels, headquarters of the European Parliament. at the end of office 2019-2024 of the European Parliament. The interpreters cannot translate because there is no sound. A new European system for migration and asylum was created. The Lisbon Treaty and the Charter of Fundamental Rights of the European Union were important documents. In 2009, asylum and migration started being the main issues. From the point of view of lawmaking, we dealt with the issue. We have been dealing with this issue for throughout our whole office. Migration and asylum are two topics that are really controversial and divisive in the European Union. Sound comes and goes. Interpreters cannot translate entirely. No sound. I think no sound, no sound. Un equilibrio fra responsabilità condivisa e solidarietà vincolante, perché proprio quello è il mandato dell'articolo 80 del Trattato di funzionamento dell'Unione Europea, che è complementario della base giuridica. No sound is available to interpreters. Interpreters cannot translate. For this reason, we have worked hard in order to reach an acceptable balance sheet. Solidarity is a binding commitment because that is the mandate that we have. A European migration system and a common European asylum system should be the basis of our work. We are now working to approve this package. The commitment of the European Parliament was to focus on fundamental rights through a new agreement on the right of asylum. All parties should stress their commitment towards fundamental rights. This is true especially for minors and non-accompanied minors. In all regulations, we have tried to maintain the general principle of the respect of fundamental rights, and we have promoted a European coordination body for solidarity so that in case of critical circumstances, pressure could be put on the European Union. This is true for Italy, this is true for Lampedusa, and there is also a very specific warrant for monitoring the fundamental rights of the beneficiaries of fundamental rights, including the right to health, the medical support, the right to legal assistance or rights that are recognized to people deprived of personal liberties, etc. The European legal procedure is very complex, is very sophisticated. Many variables should be taken into account. There are different conditions and different compromises we should focus on. Otherwise, we cannot say that we reached the success and we reached our outcomes. So if we were able to make a step forward in order to improve the situation we come from, considering our painful situations, we can consider unequal and unacceptable what we have lived because it gives too much pressure and too much burden on Italy and Spain, on frontline countries. There is no solidarity among countries. So we need a safe and reliable answer from the European Union so that we can implement a European system that is not as painful, but that puts the focus on solidarity and support. If we reach this goal, then we will have made a good job. This means that we have committed on fundamental rights. And this is true also in the migration and asylum agreement. Thank you for your attention.
Come si sono divisi, i gruppi parlamentari del Parlamento europeo come si sono divisi. Ringraziamo Lopez Aguilar per averci mandato questo intervento che dimostra la complessità delle posizioni.
Thank you, Lopez Aguilar, for this speech, which shows our positions and opinions. We saw how majorities were divided, as well as the groups of the European Parliament. Now we will have a session that will be dealing with migration and case law. We will also need to try and understand how to reconcile this pact for migration and asylum with the different European steps. Of course, European laws are higher in hierarchy compared to the other laws, the Charter for Fundamental Rights, the European Covenant for Human Rights, and in terms of Italy, the Italian Constitution can, of course, set some limits if we consider the European legislation. So the judges dealing with migrants will have a complex job to do. It will become more and more complex if we consider this new covenant. So I think we need to ponder the issue. So I would like to thank next speakers, thank them for being available. We have Daniela Vitiello, researcher of EU law at University of Tuscia. We have Giulia Perin, attorney in law at law in Rome and member of ASGI. She is very committed with these topics. And we have Marco Gattuso, judge of the International Protection Section of the Court of Bologna. He is also the coordinator of the International Protection Section and the coordinator of this session. And then we have Antonio Di Muro, Protection Associate of the United Nations High Commissioner for Refugees, UNHCR. Thank you. Then we have our foreign colleagues. I cannot pronounce. Isma Belaid, judge of the Police Tribunal of Hainaut in Belgium. Johanna Etnarovits-Sikora, judge of the District Court of Lubsk in Poland. We thank them for participating in this roundtable. It will be very interesting for us to hear from them and their experience.
I'm going to hand the floor to Professor Vitiello for the first presentation. Thanks a lot, Chair. I would like to, first of all, thank the organizers for this event, namely Professor Rigo Sara Cocchi. And this session has actually a very interesting title, Immigration and Jurisdiction, a regulatory mosaic tested in court. This leads us to reflect upon the implementation, a reform which was launched last week, which is about to 10 new legislative acts, which are part of the original proposals of the new 2020 pact, but also the asylum package of 2016. And as the Libe President said earlier, we have Schengen and Dublin systems that by now are of a constitutional relevance for the legal order of the EU. And so this just draws our attention of what might happen or what the role of our legal experts can be in this regulating the treatment of these refugees at the European borders. These guarantee safeguarding methods should be reviewed in light of these regulatory mosaic that we are focusing on today, which is due not only by the number of regulatory instruments, 10 of which were approved during the plenary, but should be also integrated since 2021. And also with the reform of the Schengen border code, which is going to be reviewed, and this is part of the proposal. We are waiting for the foreign participants to download the app in order to follow the interpretation. Let's take a break so that we can give them time to download it. So apparently for the others, the translation is working. I'm talking about the role of judges and also the type of interpretation and also the enforcement of rights. So let's try and better understand what can be the impact of this regulatory mosaic of the legal condition of refugees at the European borders. Why am I focusing on this aspect at the beginning of our meeting? That's because the Commission has talked about a fair and equitable approach whose core is the management of migration and asylum at the borders. So the borders become the center where all the decisions are made. For this kind of issue, it becomes the place where there's an increased efficiency of status screening and where also the material enforcement of repatriations are decided and where the third country nationals are held, and also in order to prevent beforehand the so-called secondary movements. This is a sort of a barrier filter that has become the responsibility of European borders, but which is increasingly emphasized by the new pact, by this reform. So let's see what we are facing. There is a transformation between the relationship between internal and external borders. And so we have to look at this from the point of view of the reform of the Schengen border code. What happens then? It happens that internal borders, from being a mere instrument of management of the cross-border trafficking, take up a new operational role that is a space of shared enforcement, but also of cooperation among the law enforcement authorities, which is based on a massive usage of state-of-the-art instruments for the purpose of predictive security. This reform has been proposed for the member states. This is the alternative, in other words, to prevent a limitation of the freedom of circulation, which is based on the clauses of recovery of internal controls available for the states. If the internal and external borders tend to approach themselves from the functional point of view, the same is true for the legal condition of migrants and refugees that fall within the regime of the borderlines. And this regime of borderlines has been redesigned through three elements. The first one is the fixio juris of non-entry. The second one is the acceleration of procedures, that is, the presumptions and automatisms. And the third one is the continued attention. Let's start from the first one and let's see how this happens in the internal and external borders. This legal fiction is based on the denial of authorization to entry into a state. This involves the physical presence of migrants or refugees at the borders of the states. I'm not just talking about the external borders, but all the borders, is not sufficient to attract them within the state jurisdiction for the purpose of the full enjoyment of the rights. And here we have the central role of the title that was proposed to this session. How can we apply this fiction to external and internal borders? Let's start from external borders. At external borders, the legal fiction applies to the general system of asylum and repatriation, which has been decided by the reform based on a so-called triage, screening asylum procedures at the borders and repatriation procedures at the borders. The first phase is the screening, which can be conducted to a structural application of the so-called hotspot approach, an approach based on these hotspots, which was introduced just as a practice, but then regulated starting as of 2015, which allows to envisage with these internment centers at the external borders a number of preliminary checks. So where the briefings, healthcare checks are carried out with the purpose of tracking down and also channeling them into the different procedures of verification of their statuses with the fingerprinting systems and a function of monitoring by the European Agency. In the case of asylum request, after the screening, the asylum seekers will be channeled into an ordinary asylum procedure, which follows the scheme of before the reform into situations in case of unaccompanied minor, where this is not a threat to public order and security, and also in case interpreter apologizes, no sound now arriving to our booths.
Questo è quindi una prima questione giuridica attorno alla quale l'operatore giuridico, il giudice, sarà chiamato a riflettere e a offrire appunto soluzioni di garanzia.
And the screening procedure lasts 7 days, and at the level of implementation, it can be blended with no sound again. The interpreters once again apologize for these technical issues. We're trying to do our best to provide the service in any case.
In alcuni casi, e questo è il principale discrimen rispetto all'articolo 43 della direttiva procedure del 2013.
So we have to consider also the asylum procedures at the borders in closed sites with a limited access, which is bound to become the new normal for the verification of asylum status. And this is the main discriminating condition for Article 3 of Procedure 2013 in case when there is a risk of forgery of documents, which is a situation that happens in 80% of cases because people fleeing for a persecution of war reasons do not bring with them a document.
Ora, quando è che può cessare quest'obbligo degli Stati di usare la procedura
So
del
we have a
2013,
threshold of
che, come
20%,
considerati
which is
dall'Unione
increased
Europea, degli
to
immigrati
50% in case of
appunto,
massive
dal punto di vista legislativo
flows.
da stanziare, quando si raggiunge la cosiddetta adeguata
So in
capacità.
case
La soglia di adeguata capacità a livello unionale è stata fissata in 30.000 persone all'anno, soglia minima, e
when
120.000
can
persone all'anno,
we stop
soglia
this
massima.
obligation of states
Queste
to
sono le
use
soglie
the
date
border
secondo la valutazione
procedures
quantitativa. Quello che è
from the
interessante
point
dal
of
punto di
view
vista che
of
proponiamo,
these
dal quale
resources to be
proponiamo di
allocated?
osservare, è che le famiglie con minori di
That's
12
when we
anni non
reach the
sono
so-called
ipso
threshold
escluse
of
da questa
capacity. This
procedura, che
threshold
sono
has
in
been
facoltà degli
set
Stati
in
membri di prevedere un
30,000
esame
people a year
prioritario in caso
and
di necessità di
120,000
della
people a
domanda.
year as a
Passiamo alla
minimum and
terza
maximum
al terzo elemento
threshold.
del triage, la procedura di sbarco
Interestingly,
alla frontiera. Piccola premessa, procedura che è stata scorporata
the
dal
families
regolamento del
with
subregolamento di asilo alla
children under
frontiera, ed è stata
12,
fatta oggetto di un atto differenziato su
we only have
competenze
the
e
ability for
giurisdizione del
member states
Consiglio,
to
e qui
envisage a
ovviamente c'è un
prioritarian
caso, quello all'interno
exam
del quale
screening
creava problemi dal punto
in
di
case
vista
of
delle basi
uncertainties
giuridiche, che sono
of
evidentemente
admissibility of
differenziate,
the
no? La
application.
procedura border,
Let's now
l'articolo
consider the
68 e
procedures
articolo
of
69.
repatriation to the
La procedura di
borders.
rimpatrio alla
This
frontiera,
procedure has
anche
been
quella
divided by the
operata in poche
regulation on the
settimane,
common
è una
asylum
procedura
procedure at the
la quale
borders, which was the
continua
object of a
l'interdizione di
differentiated
accesso al territorio.
act,
Quindi per tutti
because
questi
obviously
triage si
the
applica la procedura di
accumulation within one
interdipendenza
act
giuridica del
created
territorio dello Stato.
problems which are differentiated in the Lisbon
È
Treaty,
una
Article
procedura
78 and
obbligatoria in
Article
quale casi?
79. The border
Anzitutto in caso di
repatriation procedure,
mancata
which lasts
richiesta
12
di
more
asilo
weeks,
della
is a
persona
procedure
nella
in
fase dello
which
screening,
there is a
se
continuation of
il
interdiction
richiedente
of
chiede
access to
asilo
the
nella fase
territory.
dello screening,
So
è
throughout this
immediatamente
triage, the
ricondotto ad una
fixo
procedura
juris of
di ricorso
non-entry
alla frontiera, procedura alla
applies, so you
quale si
can't enter
applica
the
la
territory of the
direttiva dei
state.
basi del
And
2014,
this is a
115/2008,
mandatory
che rimane in
procedure
vigore
in a
finché non
few
viene
cases.
riformata.
First of all,
Attenzione,
in
gli
case of
articoli
a
2,
lack
paragrafo 2 della direttiva
asylum
CAP
application
infatti
by this
consente
person in the
agli Stati
screening
membri
phase,
di
if the
escludere
migrant
dall'ambito di applicazione
doesn't
personale
request
immediato
asylum during
i
the
cittadini di
screening
paesi
phase,
terzi in
the
posizione
migrant
irregolare che siano intercettati,
will
scoperti,
go
all'atto del
through
traversamento delle
a
frontiere
repatriation
esterne.
procedure at the
Dato che il
borders.
completamento di queste
And
persone,
the
procedura di rimpatrio
directive
alla frontiera
2015
solo alle frontiere esterne
2015
in
or
regime di
2008
non autorizzazione
applies in
sul
this
suo
case.
territorio, significa che gli Stati potranno
And this
escludere le
allows member
garanzie
states
previste dalla direttiva
to
Rimpatrio 2008
rule out
di
from
famiglie
the
con
application
bambini
of
nella
these acts
procedura di
third
rimpatrio
country
al borders.
nationals in regular positions that
E
have
qui
been found
un'altra ipotesi di applicazione
trying to
obbligatoria
cross
è quella
external
di un mandato
borders.
d'asilo inammissibile o
Since we have
infondato
this
attraverso procedura di
repatriation
riconoscimento.
procedure,
Quindi c'è un'immediata colleganza
this means that
procedurale
the
tra
states
asilo,
can
procedura di asilo alla
exclude
frontiera e
from the
procedura di
guarantees
rimpatrio alla frontiera,
envisaged
che è
by repatriation
svuotata
of
e si
2008, all those
raggiungono
that
in un
will
unico
be
atto amministrativo
channeled into
nella
the
decisione,
procedure
se
of
rilievo diverso,
repatriation
e
at
nella
the
decisione di
borders.
esecuzione del
The
rimpatrio.
other hypothesis is the inadmissible or groundless asylum application. So there is an immediate connection of procedures between border asylum procedures and repatriation procedures, with also the accumulation in one administrative act of the decision of denial of asylum and following repatriation. While this happens from the point of view of fictio juris at the external borders, let's see what happens at the internal borders. The Schengen reform introduces a law in Article 33 bis of the project of reform, where there's a possible transfer of undocumented migrants who are found in the immediate vicinity of the border line, which is the internal border among Schengen states. And this is true for forms of police cooperation regulated through the adoption of bilateral agreements between the states of an intergovernmental nature. So this has nothing to do with the EU law. This procedure is based on forms of police cooperation which are considered as an alternative to the resumption of controls at the borders by the EU member states. This procedure comes alongside other bilateral agreements that are allowed by Article 6, paragraph 3 of the law on repatriation, which are the basis of the practice of informal readmissions on the Balkan route. The literature defined this provision as a provision legitimating internal pushbacks within the Schengen area. Just like the fictio juris of the non-entry into the external border, this law is based on the non-authorization of entry into the Schengen country. The person is not authorized entry because this person is handed over to the authorities of another Schengen state with which there is a police cooperation agreement. And this is especially interesting because Article 23 bis rules out the applicability of this provision for asylum seekers and introduces guarantees for children. And also the point is how is it possible to carry out the verifications when there is a procedure of immediate implementation based on the bilateral collaboration of law enforcement authorities, which makes an automatic pushback at the borders possible. So let's now see the second point. We've seen how the non-entry fictio juris affects this procedure at the internal and external borders. And let's now see the presumption of security, of abuse of law, and of expansion automatisms. These instruments involve not just the authorization of entry, but also the veritable procedures. The proliferation of presumption of security is something that we have already seen. And more than this, also the massive use of presumption of security of third countries, in addition to an abuse of the right of asylum. And so what happens? There's a decrease of considering a third country as safe. So in order for this to happen, it will no longer be possible to approve this. So there's a weakening of the approval, and also valorization of presumptions which are quite new compared to the typical one, traditional ones. So we have the first entry safe country and the safe origin country. And so there's an alternative of internal protection, that is the possibility to declare a portion of the territory of the third country as safe and to send back the person to a safe country, to an area that is considered as safe. So there's a war-torn country, but within it there is a safe area. So I can send back my asylum seeker there. And secondly, we have the belonging to a nationality for which the rate of recognition is lower than 20%. This involves a presumption on a national basis because, of course, we are talking about nationalities for which the rate of recognition of international protection is lower than a certain threshold established by the EU law. There are also two more important elements about the lists of safe third countries.
Una lista europea di paesi
The introduction of a European list of safe countries. What does this mean? It means that the member states will not allowed to add again over the course of 2 years into a list in a country that had been cancelled from that list. So there will be a national list and a European list. First point. Second one, this harmonization of the definition of third country. This means that the reform should provide for the discretionality of the linking criterion of so between the migrant and the country that he's not allowed to enter. So this means the harmonization of the definition of third country. The presumption of abuse of the right to asylum, considering the spontaneous entrance of migrants into a country and secondary movements, means also the limitation of the right to submit the request. The Court of Justice in the Ministerio Fiscal case law talked about this right that was also provided, that was also enshrined in Article number 6. This right is limited because the state can extend the end of submittal of requests. So there is an administrative law that should impact this right. There is also Eurodac reform, the database of the European Common System for Asylum. So in this case, the asylum seekers and the regular migrants are added up to the overstayers. The overstayers are those who stay in a state without the necessary documentation, but also people that have been saved from shipwreck, also refugees from third countries, and minors starting from the 6 years of age. This is a transformation, a functional transformation of Eurodac, because it was useful up to now, it has been useful up to now to record the asylum requests. And this is a law enforcement approach, not a human rights approach, because these people are put in a list, added to a list, and this has consequences on the structure and the interoperability of databases. So this also has an impact on the volume of data, but also on the rights of access to these data. These rights will be generalized And security flags will be also added and attached to the profile of people that represent a threat to internal law enforcement and order. So the problem of the right to access and the problem of the purpose blurbing should be fixed by judges as well. The last point about this topic concerns Dublin. I haven't mentioned Dublin yet up to now because we are talking about borders, frontiers, and not cooperation between states. But this automatic mechanism is also interesting for the Dublin case because the reform considers the Dublin procedure as a preliminary phase of a pre-investigation from the state, from the country. This means a transfer of competence between member states so by default, in an automatic way, in order to avoid any hurdles that were created during the process of transfer of competence, in order also to take into account the protection of fundamental rights, or in the case of Strasbourg against Belgium and Greece. So the possibility of stopping the Dublin procedure in order to abide by Article 4 of the Nice Charter. So the member state, even though it is competent based on the Dublin law, the state, if it lacks these structures, will have a limited influence. This is what is provided by. And this also means issues concerning our internal law and order. There are judges that are now focusing on the sovereignty clause, Article 16 of Dublin Regulation number 3. So in the case of international laws, requires this in order to protect the human rights of the person. There is also another procedure of welcoming these migrants and taking care of them. The procedure was based on a formal request. Now it is based on a service to the state. So it says that the state should take care of the citizen without a formal request. So this concerns presumptions and automatic mechanisms within the internal frontiers. In terms of external borders, we have a new article from the Schengen reform, considering taking into account the internal pushback, which is also an automatic mechanism, which does not ask the member state that does the pushback, does not require the member state to do a screening procedure, because the member states are also allowed to proceed with a screening within the territory. So considering the preliminary assessment in the external frontier, in the external borders, this also happens within the territory. But if the state wants to transfer a irregular migrant to another member state that is also part of the Schengen area, it should not. It does not necessarily needs to do the screening, because the welcoming country should do it. So this is an automatic mechanism that does not have any exceptions. So the state will not know anything about this person.
Il trattenimento riguarda
A third element. There is also another topic considering imprisonment, where fictio juris is applied, and when considering the presumption of automatic mechanisms, there is also another thing that is applied, that is retention, withholding of people within the state, because as in the case of screening, also the border procedures can happen within the territory of the state and within the internal borders. Of course, the Commission should know about it, but this is within the discretionality of member states. So this concerns all steps of the triage, and it is defined by the Commission. So the use of detention is considered by the Commission as an ordinary measure. So the retention, the withholding at the frontier, at the border, what is its use? The access to the territory will be avoided, and the pushback is prepared in such cases. The welcoming conditions can be reduced also for vulnerable people. At the internal borders, the states within the internal borders can do that, can take these measures, and this system means that there will be some internal borders as if they were some external borders. This is the reason why I have tried to reconcile the two aspects, so internal and external border. So considering the legal framework we have described, now everything is clearer, and we know better where we can intervene for the enforcement of rights. In order to answer this question, we should consider two aspects. The first one is the compression of defense, informative rights, and the method that comes from the collateral effects of these measures. On the other hand, also comes from a voluntary choice of the European lawmaker. Considering the acceleration of procedures, we should take into account the automatic mechanisms and procedures we have just described in terms of choice from the European lawmaker. In the screening phase, the access to judge is not regulated. The informative rights are not guaranteed in an accessible language to the person. In the administrative phase of the procedure, there is no free legal assistance or legal advice. And in the jurisdictional case, the right to sue is not possible unless the request is rejected, if we are talking about non-accompanied minors that represent a risk for internal security, without considering the reduction of terms for report. So for the appeal, for the recourse. So what is the reason of the European legislator? It is that of reducing the litigation dispute as provided by Article 47 of the Charter of Fundamental Rights. So, if we want to compensate this softer legal and jurisdictional protection, we can introduce monitoring mechanisms. What are they? A national system for autonomous independent monitoring for the screening phase and the monitoring of the asylum agency throughout all phases and all procedures that we have just described. What is the reason why? What is the reason why we could reach this result? This result makes everything more dynamic. So this deserves to be supported. So anybody that practices these topics can understand that this is in contrast. This is against the Strasbourg case law and other laws. So the council did not want to leave this stalemate in law. So I do not have time now to go through the whole case law, but probably we will have the chance to do it during the Q&A, but we could have some guidelines in terms of asylum access and procedures at the borders. So we created such possibilities.
Il caso MA contro Lituania della Corte di Giustizia, ma anche per esempio il caso Commissione contro, mi viene in mente per esempio il caso preliminari.
There is also some case law MK against Köln from the European case law. This is an example. So the instrumentalization declaration in order to avoid access to asylum procedures is another case, as well as the case Commission versus Hungary concerning an asylum request and the relationship between internal and external borders of the EU. They cannot be considered as the same issue because their function is different within the free movement area of the European Union. And there is also dialogue between courts, the courts of the several countries. There is another case law commission against Hungary. So So the internal law is in contrast with the European legal provisions, Article 47 of the Charter for Fundamental Rights. And then the case law of the and other cases concerning Italy. So Article number 3 and 8 of the European Convention of Human Rights and Article number 4 of Protocol 4 should be abided by. So there cannot be any pushbacks happening on a second moment. So this will protect the individual guarantees and the goal of the European lawmaker will not be implemented. Thank you.
Ringrazio molto la professoressa Vitiello, un po' sforato.
Thanks, Professor Vitiello, even though we had we have a slight delay, but this legal framework was very important to us. I don't know if Sarah will need to give you some technical information because there are some issues to be fixed. Please, Sarah.
Buongiorno a tutti e a tutte. I will speak Italian first and then from Google Play or the news interpretation. Okay, so I'll start with English. Fine. Sorry, my brain is not right now like divided into 3, 4 pieces and blocks. Fine. No, as you know, there is simultaneous interpretation available. You can download the app Interactio from Google Play or the App Store, iOS App Store, and you can access the simultaneous interpretation by entering the code MEDEL 2024. It should be available right now. You can select both languages as you deem appropriate. These are all the codes for accessing the Wi-Fi network. There are 2 different networks, so you can choose whatever is suitable for you. Nothing, of course, to use the simultaneous interpretation, you need your own headphones, earphones, headset, whatever you have. I think that's all. Quindi lo ridico in italiano. A posto, non c'è bisogno, l'hanno tradotto, è vero, geniale.
I was going to translate it into Italian, but the interpreters have already translated it. But some haven't listened, so I'm going to repeat it. You need to download an app called Interactio from the App Store, and then you have to use the code MEDEL 2024 and choose your preferred language. You're going to have to use your earphones to listen to the translation. And here we have the passcodes for the 2 Wi-Fi networks. Zoom is actually working. We have a different link if the one you have is not working.
La necessità è stata, diciamo, risolta alla fine con il team di Interactio che si trova attualmente in
You
Lituania.
still need to download Interactio,
di Zoom, ma
but you can also follow the streaming on the YouTube channel of Magistratura Democratica. Sorry for some glitches at the beginning, but luckily enough, the Interactive team was able to solve all the issues. They're actually based in Lithuania, and there was actually some problems setting up the Zoom connection. I would like to thank Sara for taking care of all the technical aspects relating to the organization of this event. I would like to thank the previous speaker for the overview she provided on the main critical areas, criticalities relating to this new pact. I think that the appeal launched back in December by the special rapporteurs of the UN for human rights wasn't transposed because they were already highlighting these criticalities that have been highlighted now by this speaker. I think that there are different standards in Europe because the one that was sentenced, condemned by the Court of Justice was Hungary because they were just not complying with any of the human rights principles. And now Hungary will be forced to recognize at least some of the human rights. And so the human rights also recognized by the EU Charter of Fundamental Rights. But we have to admit that this new pact has reduced the safeguards. And I think that's when we are in a rule of law in a European Union that protects the rights of people as such, not just the nationals of the European Union, when we have double standards, it is the rule of law and democracy as well that are jeopardized. So we have to focus on this aspect, I guess. Now I would like to hand the floor two speakers having more general topics. And then we're going to hear from the judges who are going to tell us about their difficulties they're experiencing right now. Of course, in the interest of time, we can't just delve into all the topics. It would take a month to delve into the different topics. So now I'm going to hand the floor to Antonio Di Muro, who's here on behalf of UNHCR. So we're going to hear the standpoint of the agency, and we've already read it on the newspapers, but he's going to report it as well. Thank you, President, and thank you, Magistratura Democratica. And also, I would like to thank University Roma 3 for having me. I'm quite pleased to be here in front of you, not only because my agency considers the judges and the academicians as invaluable allies for the protection of the refugees' rights, but also because I have here an opportunity to present the standpoint of my agency. Some of you've already read about it, but I'm certainly going to provide you with a more comprehensive overview. This will not come as a surprise for you because we've already several times confirmed our standpoint throughout the process of approval of the pact. We believe that if the pact will be implemented in a way that is respectful of human rights, we'll have the opportunity to be a very important breakthrough towards a more harmonized and efficient system for the management of asylum applications on one side and also protection of the rights of asylum seekers and refugees on the other side. After clarifying our general standpoint, I'm going to focus on some of the instruments, and in particular the screening regulation and the asylum screening regulation. In the interest of time, of course, my presentation can't be as comprehensive as the one that the previous speaker has done, but I'm going just to touch upon the different aspects in a more general way. Let's start from the first aspect. The idea is that all the people arriving in the territory of the state have to undergo a screening procedure, not only in order to identify their identities, but also in order to understand what are their specific vulnerabilities and needs, is an idea that our agency has been embracing for some time now, and we're especially satisfied about the fact that the health and vulnerability checks now are fully included in all the legal space of the EU as essential and fundamental parts of the screening process. As concerns the healthcare part, the screening regulation ambitiously asks that this procedure aims at identifying any healthcare needs. In a previous draft of the text, there was a reference to any immediate health care, but now they have removed the term immediate, but anyway, all healthcare needs must be identified, and in case of identification, the access must be permitted both to the emergency healthcare treatments and also to the healthcare treatments of an essential nature. As concerns the preliminary checks of vulnerabilities, I apologize. I have prepared on English language texts, so this is why I'm struggling to find the Italian words, and probably this will not match with the corresponding text that you will find into Italian. So I was talking about the vulnerability checks. They are going to be conducted by specialized staff that has to be preemptively trained. And here the purpose is identifying any indication that the person might have some special needs in a very clear way among the different situations in this area. We have to identify the possibility that the person might be a victim of situations of torture or mistreatment, and also any indications that this person might be in a situation of statelessness. So this stateless condition is considered to be a vulnerability aspect which has to be identified and reported. And this, of course, will imply a review of the screening procedures for the vulnerabilities. There is also the possibility to provide assistance by NGOs. And while it is true that the instrument refers to a number of limitations, but it is also true that these limitations do not have to impact the core of the rights, which means that they must not prevent de facto an access or an entry of the migrants. Let's now get to the right to information. Under this aspect, a protection of the right to information is provided for, which includes the right to be informed before applying for asylum, and there is the right to apply for international protection. And this is true in any case when there is the possibility that we believe that this person might apply for asylum. So we must inform this person before they apply for asylum that they can apply for international protection. So what are the cases of non-complete protection? This has not been defined yet, but also the Italian jurisdictional experiences against that in this respect can also explain within the European Union what we mean by the right to information in relation to these aspects. As for Article 6, paragraph 7 says that an appropriate staff and resources must be deployed for an efficient screening. So it is in the breach of this instrument not to invest or to deploy sufficient resources in order to carry out an efficient screening procedure. For the attainment of this objective, Article 6C, or the people, not only asylum seekers during the screening phase, must have a guarantee of a standard of living that not only guarantee their standard of living, but also that protect their physical and mental health and all the rights falling under the Charter, that is mainly the freedom of the people. So during all the crises, both informal and formal ones were always in line with these needs. And now we have a clear formulation of a legal obligation, which is accompanied by the obligation to fund the system with adequate resources, which has become a standard. And here the challenge is to put into practice this objective. And so this is the challenge that I launched to the community of jurists. Article 7, independent, autonomous monitoring activities. And in this case, the regulation is very clear when it comes to defining independence. That is the reference to internationally consolidated principles identifying the features of an independent body. In particular, there's a reference to the Paris principles. And I guess that right now in Italy there are no organs of control that apply the principles of Paris. And here we need to have a monitoring procedure that meet this criteria. And we need checks to be carried out randomly and not based on announced cases. So in order to prevent an inappropriate exchange of information between the operators and the migrants that will be checked. Let's now get to the aspect of restriction of personal freedoms. Since over the years, in the hotspots, the European Court of Human Rights has identified some situations as de facto detentions. It is not an authorization of a de facto detention, what we can find in the text of the screening regulation, which talks about restrictions to the freedom of movement, explaining that instruments must be deployed in order to prevent that people remain available for competent authorities for screening purposes. If this should in practice translate into a de facto detention, this will be by effect of a poor implementation of this instrument. The instrument doesn't talk about systematic automatic detention, but only measures in order to make sure that these migrants remain available for the screenings of the enforcement authorities. And so only in exceptional cases in which detention is the only proportionate and efficient instrument to achieve a legitimate purpose. Let's now get to the asylum procedure, and also the most controversial part of this instrument. Certainly, the main novelty in the instrument is a strong incentive of the border procedures, and in some cases they are mandatory on the border states. And here a question rises. That is it compliant with the refugees' rights for diversified procedures? The answer is it depends. It depends because Article 31 of the Geneva Convention of 1951 bans the application of penalties to the people, asylum seekers, for the mere fact of their irregular arrival from territories from which their rights were not protected.
quindi compatibilmente con i principi fondamentali e le garanzie di cui al
Let's see now the content
quindi le border procedure
of these border procedure.
questo strumento non devono
Let's now see how we can provide guarantees. Well, Article 44, first and foremost, the border procedures must be implemented in accordance with the fundamental rights and guarantees under Article 2 of the instrument. So the border procedures under this instrument must not be organized as secondary procedures, but they have to be seen as procedures in which, despite
su questo profilo le garanzie sono state rafforzate, direi,
a reduced timing, all the fundamental guarantees of ordinary procedures must be fully guaranteed and without an exception, starting from the right of information and then going on with the right to interview. And from this point of view, the safeguards have been strengthened compared to the existing directive, including also the admissibility and also the conditions for the interviews are based on the standards because the challenge is taking them seriously and making sure that they are taken seriously so we have appropriate privacy.
Or they are organized so that they allow people to report the reasons of their request in a comprehensive manner, or those who are able to ensure the appropriate communications and the interviewers that are competent to do that through continuous training, so that they can take into account the general circumstances of the origin country, the country of origin, such as age, gender, vulnerabilities, etc., so that they know, so that they have professional knowledge in their subject matter, but also a general knowledge of the facts that might reduce or limit the ability of those who should be interviewed to participate in the interviews. So the video conference is admissible only when justified by specific circumstances, and in such a case, it should be accompanied by the implementation obligations with the necessary arrangements so as to guarantee the technical aspects and relational aspects as well. The assessment of procedural needs must also be operated on an individual basis. So we should not attach labels to people, but it should also bring to a real taking care of those people, victims of torture, victims of serious cases of violence, etc. So once these vulnerabilities are identified, what happens? The alternative is and can be found in the directive. It is now strengthened and empowered. So these people should receive the support that cancels the inhibitory effect of this vulnerability, or they must be excluded from the accelerated procedures. This is true for victims of torture or victims of violence, of physical violence, etc. Or people that have gone through difficult periods during the transfer experience. As far as a safe third country is concerned, the professor raised the important aspect of the harmonization. De-harmonization is a strong word for me because in the legal instrument there is no provision that raises this issue of connection of people to a country based on some specific criteria. But this notion, this definition must be such so that for a person going to that specific third country becomes reasonable. And this is this has to do with an autonomous definition. It should be defined, but legal experts, national legal experts, and the European Court of Justice will have an important role to play in such an issue. For example, some connections, some links that might be made these cases legitimate or reasonable are also taken into account. In terms of non-accompanied minors, we have said that only in the cases of possible risks for their safety, these issues should be treated in the procedures for borders. And if there are no conditions for detention, the procedure is not applicable if an alternative procedure without detention is feasible. So if we consider the situations caused by controls on the movement of people, there are in some cases differences in intensity if we consider detention or other forms of movement prevention. And where conditions are comparable to detention, people must be able to avoid the procedure. So my conclusion is not to be optimistic, but to operate so that the conditions become more optimistic. Thank you. I would like to thank Mr. Di Muro, who said many important things, and I expect to get some guidelines from the UNHCR on how to apply this pact in harmony and in line with international obligations in terms of human rights and rights of refugees. So it will be very useful for European judges to get some guidelines from the UNHCR. I appreciated the speech because it stressed the need for implementing and applying a pact in line with the international obligations and the human rights, fundamental rights of migrants. The quickness of procedures is an obstacle, it's a hurdle to the procedure. Let's think of the difficulty in finding vulnerabilities rapidly and in situations of detention. So I understand that everything that is now happening, for example, in Belarus or in Croatia, we have seen that
anche quando arrivano davanti al giudice e quindi dopo che sono qui da tempo,
from the point of view of the rights of migrants, we know that there are some main vulnerabilities. We need time, we need a safe place, we need a welcoming and comfortable place. Let's think of people, victims of human trafficking. Trafficking victims when come before a judge or when are in some specific reception centers for psychological support. They do not admit having been victims of human trafficking. So admitting such important vulnerabilities also when determining the migratory flows in that specific timings and being able to for migrants to find a comfortable situation and to be understood takes time because these people are traumatized. They come to the border with trauma, and they are anxious about coming to Europe. And if we stick to the timings of the pact, it would be difficult to them and to us to support them. So for the judges of the migration session in Rome, they agree about that, and we will hear also other points of view of other judges. I would like now to give the floor to lawyer Perin, member of ASGI, and then to judges. I will keep it short and simple. I only have a sheet to summarize my speech, but I don't know if I will be able to be so brief and short. But I would like to share with you some reflections, some thoughts of mine, and some answers I gave myself to some questions. What is a pact and why a pact? What changes for us with this pact? What is negative about the pact? And one more point, as a judge who implements human rights, is the battles that we have in front of us and what the best battle for us would be. So first of all, the pact, because pact or agreement for me is something different compared to a directive, a regulation, which we already know. Then comes the pact, the agreement that must be approved. In order to understand what we are talking about, we can define it as a package. So many measures that were mentioned earlier by Professor. So a pact is a package of measures. And what is interesting is that the Commission just said either everything or nothing. So let's find an agreement, and when we found an agreement, then let's stick to all or nothing, because the interests and the goal was that from starting from 2015, 2016, we understood that the European system that was created was not very effective because Italy, and not only Italy, followed the suits of everybody, and Germany said, I do it myself. I do everything by myself. This was seen as a Dublin conditions not being applied. So the South started to say, we cannot do everything by ourselves. So pact became a measure among states. Lopez Aguilar said, it has been painful for us, but then we managed to do it. We managed to reach our goal, Italy and Spain. So a pact comes to a state. So interests of the different states are treated, are taken into account. The problem was that the system had too many gaps, and the interest of the asylum seekers was secondary. We need to respect fundamental rights, but what brought to us this pact was a relationship between states. So states that find an agreement at the European level. Before the European elections, the image of an ineffective European Union that is not able to manage migration brought us to finding an agreement in December. So I think it is important not to forget that when talking about those who win or those who lose, we are talking about states, and we need to understand where people are, so what their position is. This is important because we can say somebody is a step forward in terms of management, in terms of migration, or some states have more solidarity and they can move people. What changes with what does the pact can change? So, as our UNHCR member said, if we have a look at some provisions, some of them are really positive. So if we read them in an impartial way, without biases, we can find some significant improvements. But what I asked myself about what we have today with the pact is a change, is a model. So we are presenting to the world our asylum model. This is what will we be about, what we will look like. Until 2013, we had an asylum system, but a procedural autonomy. The European Union said we have all of these procedures. The state can choose, and only the ordinary procedure had to be chosen with many guarantees. But behind that directive, where the procedures of many member states that implemented those procedures, and the Commission and the European Union said these are the models, and it said to the states, if Italy, you want to abide by this procedure, then you should abide by Article 43 of the directive. So we had, in that case, some procedures that each state could choose, but the European Union did not say that there was a preferable option. In all occasions, we said the border procedure must be the exception to the rule because it means detention. In 2013, the Commission said that what has changed today? So we do not have many countries with many procedures. So we do not have many procedures, as many procedures as the states are, but we present to the world our system, which is a system that starting from the exception of border, we move to the rule of the border. So if we ask Europe, what is your system? We will not say we just have a federation and everybody does what they like, but there is such a system in place. So it was a need. It was a need. And in 1999, we made a different choice. We talked about an open Europe, a Europe that is that pays attention to human rights. So the frontier, the border, is compulsory, and it has become in most cases, for most people, something important. Where does it come from? We make possible in the procedural agreement for the states to apply it when migrants come regularly to the border, but we also oblige all states so we oblige the member states to do something. It's not just may I or shall I, but I must. So people coming regularly are many. There are many of them. As the professor was saying, there are some people that will fake their condition. There are some dangerous people. But the true issue is that 20% of the approval rate of judicial decisions, but also first level decisions. So it's a different level. How many are they? 20%. There is a presumption of abuse. 20% means that 1 person out of 5 would have the right to asylum. So if we consider a country that produces much migration, much migrants for job reasons, for work reasons, but also other people have a good reason, then I need to get angry with those people who ask for asylum, because 20% cannot receive what they should get. So it would be interesting to see those states that reach 20%. Not many of them go beyond 20%. Some states are safe. We have a list. And these are the states producing more migration, but with the 20%, all states become so there is a change from 20%. 1 out of 5 should be involved in we should play with statistics. There are some guarantees, those who have some reasons or less reasons, but we can move from 50 to 100%. So this rule is the rule of the border. What does the pact change? There are some improvements, but in my opinion, today, when I say these are the features of Europe, so the linguistic pluralism, I will need to say Europe's feature is this pact. We have our system, this was our choice, and it was a necessary choice. Then I move to another conclusion. What is negative about the pact? I was worried about the question.
Che non tira in conto la giurisprudenza. It is not a person that does not take into account the case law, nor a government, for example, like Hungary. Well, with the failure to apply the right of asylum, Hungary managed to eliminate all asylum seekers. But there wasn't the Hungarian government that did so, but European institutions that tried to do so. So I was just making a reflection on this, but I'm not sure that I can continue. If I can't, the president will certainly stop me from doing it. I mean, what are the grounds for this? What is this fiction of non-entry for? Well, obviously, and all the norms apply, but why was it done? That's because of the European Court of Human Rights, when there is the case law for the case of individuals who haven't been received, authorized yet, is more generous for these people, but they want to lower the standard. So there was the idea at the basis of this fiction. What's wrong about the pact? I have 5 reasons why I don't like it. One is the hypnosis of efficiency, of functionalism. Well, while it is true that detention makes expulsions more efficient, but it is also true that this cannot be an end in itself. I mean, a person who's now an Italian national had to stop to Iran because in order to make their enforcement procedures easier, they were shooting at people. So I really was forced to stop. But we need to understand the usefulness of this. And we need to remember that detention is a wrongdoing, and it is not the ethical principles of people saying this, but the underlying value of our system that ranks as the first of rights, as the personal rights. This right is considered as being undeniable. But even more than that, all our constitutional system is based on the principle of axiological precedence of people compared to the state. So we can't just do everything because we have a purpose to reach. So we should wonder, is it good or bad to detain everyone? Well, we must, for example, say, okay, we are doing it, but we have to face the fact that this is not fair. Then when the law says this can be done, this doesn't just have an effect in the legal world, but also in people's minds. We are doing what was called mural frontiers, that is symbolic separation lines that put some people outside of the margins in which we want to apply moral and justice rules, things that would never be acceptable for our family members. So we are just launching a message to all of us, which is then introspected, because there's a power of confirmation of what is right and what is wrong. Third problem, the silence. As Antonio Di Muro said earlier, it is true in this border procedure, both through the screening procedure and also in the pact and the procedure, the regulation never says that we should detain all of them. It is not stated. While here, I find this as a big responsibility. In the past, the Commission said the border procedure imposes the detention. Now it no longer says so. It says something different. It says that you should detain them at the border, but if you can manage without detaining them, it's for the better. So it's just like saying, okay, you can fly. If you can fly without wings, that's good. If you can't, that's good as well. So if you make a choice, you have to be responsible for the choice you make. I mean, and not try to get rid with it. And probably in some places they could consider a system in which there is no detention, and people, for example, there was a system where this was possible, but except a few exceptions, border means detention. So not saying this doesn't mean that this is not happening. We need to clearly state this. Fourth point, any malicious action by Europe, because let's assume there is no problem from the legal point of view, that everything is perfect. In this period, we have shown that we are not capable of respecting fundamental rights at the borders. We are taking a risk, and we know this risk exists. The risk that we do not respect the fundamental rights of these people, and this is proven by the huge number of sentences that we have received. And as Professor Albano said, maybe Greece, Italy, Malta, we are unable of doing this. But the Mediterranean peoples didn't have the illusion of known borders, were not able to be so efficient. Well, okay, but time is a value. It is an asset. So doing these things in a short time, well, of course, everything can be made more efficient, but there's a minimum time below which you can't do your job in a good way. For example, when I'm trying to write something down, I need to take my time to do it. Lastly, we have the difficulty of the government, of despair. Well, actually, the detention of migrants to be pushed back is more difficult for those who need to manage this than for the detainees themselves, because these detainees have the promise of reduction of the penalties. So in this way, we can avoid that despair is the only possibility, because there's a high rate of suicides and also mental health issues. So you can't give anything to these people except the pushbacks or volunteer repatriation. And then the very fact of living with desperate people is not a good experience, although you're not desperate yourself. I can remember a woman from El Salvador who hasn't had access to the international procedure in Rome because this was denied to her many times. And she said that she doesn't want to try anymore because she lost her sleep on seeing some other people being mistreated, being moved over and over again, by seeing what happens in these detention centers. Now, I would like to add something. I don't know if I have time. I'm just asking. Well, I don't know if we can have a second round of table. So if you want to add something, you can do it now. Well, then I prefer to close here my speech so as to leave time for the others. Thanks a lot. We have really a very rich debate this morning. The pact apparently is also eliminating essential safeguards, as it was stated by the previous speakers, and also for the guarantee of national residence of permit or other reasons, which means that national states are obliged to apply the pact. And apparently these supranational European regulation, I'm asking, can these supersede our national constitution? We have to consider the counter limitations and the role they play. Now I want to hear from the judges, from the European judges, who are going to tell us about their experience. And let's start with Marco Gattuso. Thank you, Silvia, and I would also like to thank the organizers for giving me the opportunities to be here with you today. for my presentation, I would like to focus on the new common procedure regulation, and I will also touch upon the consequences on our constitutional framework. The new regulation replacing the 2013 directive in its incipit at the third paragraph has the objective of creating a common procedure that is going beyond the differentiation of procedures, avoiding secondary reference point. And this is the second recital. The first thing I wondered is whether it is true that the difference in procedures and also the possible variation in the amount of applications can affect secondary movements if we consider the countries in which there's a larger rate of variations. For example, in Afghanistan, there's a reception rate of 2% in Cyprus to over 89%, which is for Italy. The same is true for Somalia and Iraq, and the range is 20% on one side and 70% on the other side. But Italy, which is always at a higher level compared to this, accepts more than 2% of asylum applications. So the migrants are happier to go elsewhere, despite our high rate of reception. But if we consider the three countries for which most of the asylum requests are made to our country, namely Bangladesh, Pakistan, and Egypt, the Italian rate of reception is not higher in terms of international protection, not a complementary one, but the regulation is about international protection. So the rate of reception is not higher. In the afternoon, I think that Professor Ambrosini is going to expand on these subjects, but undoubtedly there are variables affecting the choice of the country to which they ask for asylum is connected to the presence of members of the family or friends in that country and the possibility to get a job. And they're not connected neither to the rates of variations of decisions, and even less than that, to the type of procedure. So if this is the aim of the regulation, it is probably groundless. On the other side, there's an adoption of a common procedure which is going to supersede the procedures in the individual countries, but we are still applying Directive 32 of 2013. There is just an indication of some common principles, just a draft, but what still applies is the principle of autonomy of individual EU member states. There are some elements which go in the direction of a greater harmonization, but these are secondary elements. As we said, the list of safe countries become European, but there is also a possibility to have national lists. They also say that in reiterated applications, the guilty principles will be taken into account, but this is not a common procedure, of course. Another important element is the completion of the reform started in 2021, and the important role is given to the EUA, and their importance is called for in different regulations, and I would like to urge MEDEL to have a special attention to internal dynamics and to the rules that will make a greater autonomy for this body. So since we are fact, let's face it, we're not going in the direction of a common procedure, which is not going to be able to affect secondary movements. And as it has already been said, this new regulation will bring about a reversal of the relationship between rule and exception and accelerated procedures at the borders. So there's a reversal of the procedures, and so the border procedures become mandatory, and this happens through the introduction of a new law, new rule in some countries with the reception rate lower than 20%, but then this rate increases, but other speakers have already talked about this. In Italy, we are focused on specific countries: Morocco, Tunisia, Egypt, Bangladesh, Pakistan, and Nigeria. These are all countries for which we have a recognition rate lower than 20%. So for all the asylum seekers, the ordinary procedure will remain the same. The only country which is higher, the 20% rate, is the Ivory Coast, and this should lead us, despite the regulation will not apply immediately, but just in 2 years' time. So from the interpretation point of view, we have a doubt about the inclusion of Ivory Coast in our national list of safe countries. I think this is the main novelties, the main element of novelty. This becomes a mandatory procedure, and it is accompanied by specific choices relating to the border procedure, but this also includes transit areas, people that have been rescued in international waters, and also individuals that have that are under a warrant of arrest due to an irregular entry. So this connection, what is this connection all about? We'll have to interpret this, and I think that the first element for the interpretation is that recital 57, I guess, says that by connection we should mean at the very time of the regular crossing. So the reference is to time, to timing. So the immediacy, you cannot think that there's a border procedure because the following day you were the object of a warrant of arrest due to your irregular entry. But there's a connection that is due to the time, the moment of crossing of the border. When the regulation introduces these border procedures, it also connects to a duty of the states, it says should, to implement forms of restriction of the personal freedoms. It's been discussed whether these restrictions should be translated into detention, but we can talk about the possibility of a state to force a person not to move from a place. This place must possibly be the border. It can be any place within the national territory, as long as this person indicates where they will be located. This place will not be a house, and presumably this restriction of the person's freedom doesn't seem to be a house arrest, but it resembles much more to a closed place, a penitentiary prison, I mean, in which also the minors can be detained. Then we have a number of exceptions, namely the vulnerabilities, but it is very difficult to identify these vulnerabilities in today's, despite some limitations. So what is the element on which we need to ponder? we have an administrative detention, which appears to be a massive administrative detention without a regulation. And apart from evoking general principles for the defense of human rights, there is no penitentiary regulation which would be the right of these people committing a crime because they're suspected of committing a crime, and we don't have a judge monitoring the enforcement of this deprivation of personal freedom. We just call it surveillance judge in our country, but because of course they carry out the surveillance in these prisons, and all detainees talked about forms of isolation and also stale food that was provided to them, like the orange, etc. And we have also other countries, and we know that Article 3 of the ECHR says that we should protect these migrants from inhuman behavior, inhuman treatment, and which is in line with the principle of non-refoulement. But we talk about degrading this human behavior when there's a restriction of personal freedom. This Article 3, in connection with Article 14, that bans discrimination based on race, etc., should somewhat call on our attention on the need to verify whether there's disparate treatment between detainees that committed a crime and also detainees that just crossed the border, whether this is compatible with the framework of
the cap in terms of the effective application of the procedure at the border, and this retention procedures has to do with the ability of the country, the capacity of the country, 700,000 at European level, for example. And this opens up one of the main issues, because the parameter of the adequate capacity is not a legal parameter, it's not a legal standard concerning the subject in the case of a crime that becomes a suspect. But they can go to an institute where they are deprived of personal freedom. Who chooses who goes in prison and who does not? Only the police. There are no judges. The judges can convalidate the decision or not, but the police authority has that power to put people in prison based on a legal framework. There are tens of thousands and hundreds of thousands of migrants, and only to some, so a small share of them will this procedure of detention will be applied. So this happens at the level of the police. The police decides who is detained in prison or not, based on their discretion, on a discretionary basis. So, considering this framework, we need to consider Article 10.3 of the Constitution. We would need a one-day conference to talk about it. The right of asylum is well known to Italian colleagues, but talking to foreign colleagues, Italy is lucky enough to have a unique law on the right to asylum. Our constitution recognizes these rights not based on a persecution danger, but in order to ensure the exercise of the democratic principles enshrined in the constitution. So the Italian law is wider than the Geneva Convention and several directives and principles of the European Union in such case. And the right to asylum in the Italian constitution is also guaranteed not only as a right of stay, but also a right of entrance to a country. So we didn't have any application law of article number 10, but we had some case law. Some of you would remember some judgments of 2019, for example, where the judge ordered the state to allow for the entrance of people that had been pushed back so that they could submit their request to the right of asylum based on Article 10. So our law is subject to constitutional review, and that is a law, a provision that might be applied also in order to also not taking into account the principles of the directives and regulations. This provision enshrines an absolute reserve of law. Rule of law. So this discretionality principle talks about personal freedom and condition of asylum. It is compatible with a provision that would impose an absolute rule of law if the conditions of the right to asylum are now given to the administrative authorities or police authorities based on the EU law. One last thought, in order to deprive somebody of their personal freedom, Article 13.1 of the Constitution, etc., we need a reason. So what does the regulation say? The regulation says more times that persons cannot be deprived of personal freedom if this is useful for being expelled from one country. Those who are detained will not be expelled from one country, not because of lack of identification, etc., but because they come from countries with which Italy has not reached agreements that allow for the legal expulsion from the country. So for these people, we cannot say that the reason provided for by the regulation is founded, because sometimes people are detained and we know that the expulsion will not happen. So there is another reason, another function. So the function of deterrent. So we do not let enter people at the border so that they do not come to our country, and we think that those who do these journeys, 6,000 deaths in the Mediterranean, for example, or in the Balkans, or sometimes I hear about people from Istanbul. They come by walking after 7 months, and they are rejected at the frontier. Some of them go through the desert. They get on a ship, and these people can decide not to leave Bangladesh or Senegal because there is a non-concrete hypothesis that they can be deprived of personal freedom. So we need to verify to check if this hypothesis is likely to happen. So this mechanism in the regulation should be seen by taking into account that reasonably enough we will not get a particularly evident effect and it will not have an effect on the migratory flows, which will become the same. In terms of deprivation of personal freedom, it has a symbolic meaning, so establishing and drawing a line, a border between us and others and the rest of the world. This is the ideology and the culture of the past, but it also has a symbolic meaning beyond a practical meaning, because by using this discretionality, the police authorities can have this tool in order to manage social marginalization. So I think that in the 21st century, we still have a sort of detention system which comes to the surface again. It never disappears just because it is written on paper in a tool that is practically a European regulation. Thank you. Thank you, Marco. Thanks a lot. Now we hear from our European colleagues. We move a little bit. We don't have the microphone. So you can sit down there. Thank you.
Mi riesce molto difficile pronunciare il nome della collega polacca a cui ora do la parola. Ho chiesto...
Avete preferenza su chi vuole parlare prima? Ok.
Who would like to talk first? To speak first?
Mi riesce molto difficile pronunciare.
It's difficult to me to pronounce the noun of the colleague from Poland. Okay, let's just say Sikoa. Thank you.
I prepared myself for today's meeting. I want to start. Okay. So, thank you for your patience. The conference is quite intense, and I am totally aware that you are quite tired. But before I start my presentation, because I prepared myself for today's meeting, I would like to ask one question to you. How many of you have been visiting Poland, has visited Poland for the past 6 years? Wow. Okay, not bad. So many of you know that before 2021, Poland used to be a very homogenic country. Culturally and ethnically, we are quite unique. I have to admit it, because it determines the thesis of my presentation and my speech today. It's the fact that we used to be quite monoethnical, and the fact that Poland never used to be an attractive destiny country for migrants, caused that Polish legislator decided to apply international migrant law in a very good way. We had really good, we have very good measures to protect and to assure the rights of migrants. We have a lot of different instruments to legalize the stay of a migrant in Poland, and I will try to show it to you. I prepared a lot of details about those solutions, but of course I'm not going to present them because they are pretty boring. and it's very hard to remember everything. But needless to say, in Polish legal system, we have very good solutions. The solutions which fit European law, which fit international, conventional law. The problem is that, in my opinion, Polish legislative powers were not aware that these great instruments may be applied or used in a high number of cases. It occurred in 2021, in fact, when the migrant crisis started. As you probably know, Poland has an external border of Schengen sphere, and that is our eastern border. We are neighbors of Russia and Belarus, and migrants came from there, from that side, from that direction. It occurred that we became quite intense, attractive smuggling path, and that we are not a country of destiny, but a country of an important stop for a further route of migrants. In my opinion, Polish executive powers and Polish legal system was not prepared for that. And Polish executive powers, which ruled that in those days, 2021, they created the measure which is an important obstacle to use those great instruments of legalizing the stay of immigrants in Poland. Of course, I'm talking about pushbacks. That is the instrument which occurred, which was created in Poland in 2021. And I have heard a lot about pushbacks here from Italian perspective, but I would like to admit that in Poland we have two different kind of pushbacks. One, the first one, seems to be quite familiar to solutions which may be met in other European countries. But the second one is something which is typically Polish, and I would like to present both of them. The first pushback is created according to Article 303b of the Foreigners Act. And according to this article, if a foreigner is apprehended immediately after crossing the Polish border in breach of the law, the commanding officer of the border guard, post with a jurisdiction over the place of border crossing, shall A. Draw up a report on border crossing, and B. He or she shall issue a decision on leaving the territory of the Republic of Poland. Decision. This decision can be challenged. Of course, challenging this decision does not stop the execution of the decision, which is quite important. But as you see, there is an instrument which creates a kind of administrative decision which can be challenged. So the addressee of this decision is allowed at least to try to stop these proceedings of pushbacks. However, this kind of pushbacks in Poland is not very often. Why? Because in 2021, in Polish legal system, the other kind of pushback appeared. And that is the regulation on return foreigners, which appeared in the ordinance of the Minister of Internal Affairs and Administration. This act was issued in 13th March of 2020. The funny thing is, the interesting thing is that this instrument was created as a temporary measure, but in fact, we Poles know that this measure still exists in Polish legal system and still is the basis of pushbacks in Poland. Why it is so dangerous? You can see that the creation of this, the idea of this instrument, in fact, the board guards officers are allowed to physically push back people from the border with no decision, no protocol, no collecting data, with no evidence which rests, which stays in papers. We don't know how many times this instrument was used in Poland, but we know that it is still being used. Maybe not as much as 2 years or a year ago, but it is still an instrument which is used in Poland. And the second pushback is definitely the worst evil than the first one. In my presentation, I skipped it, but in my presentation, I had, for and against arguments whether this pushbacks based on decision can be declared as legal or in accordance with the law or not. And there is a discussion about it. We know, for instance, that there is one judgment of Grand Chamber of European Court of Human Rights in the case of ND and NT against Spain, application from 2015. And in this judgment, these kind of pushbacks, organized or based on decision, is declared as not legal, but it is possible to use it. But you cannot find any decision of international court which would legalize or appreciate the physical pushback. We know that it is totally against the international law, against conventions, but we also, and I am really thankful to my colleagues, judges, we started to see that these kind of pushbacks are also not in accordance with Polish law, because these pushbacks are created on the basis of ordinance, and this ordinance has no delegation in the law. So that was the fact the Minister of Internal Affairs who decided about issuing such an legal instrument to the act of lower position, such as ordinance. I will skip the topic of pushbacks in Poland on this conclusion. Maybe I would like to underline one thing. We really don't know how many people were the victims of such pushbacks in Poland. What we know is only the top of the mountain, and I am sure that in the second part of our conference, Madame Ochojska will say much more about it, so I will leave this floor, this topic to her. There are some info which come to us via media, but they are always shocking. So we know, for instance, that someone who was pushed died on the border, and his body lies on the zone which doesn't belong to anyone. So Poland does not want to take the body, and Belarus either. So that is the moment when when public opinion starts to know about pushbacks. This instrument really is an obstacle to start to reach those great instruments that we already have in Polish legal system. And if you think that pushbacks are only used on Belarusian border, you're wrong. We have a European Court of Human Rights judgments concerning pushbacks on the border with Ukraine. So it's not only the Belarusian problem. What are the great measures to protect the rights and safety of the immigrants after irregular border crossing in Poland? There are, in Poland, it is possible to give a decision on obligation to return. It is possible to legislate of the stay of a foreigner. There are some measures for the protection of foreigners' rights provided for in the Migrants Act, and there are other measures which are contained in the Act of granting protection to foreigners. I will skip all the details of those decisions and conditions which might be fulfilled, which have to be fulfilled to be given such a decision. But I will only mention that, for instance, in Polish Migrants Act, we have at least 4 different measures to legalize the stay of foreigner, such as consent to stay for humanitarian reasons, permission for a tolerated stay, family connecting, granting a residence permit on the territory of the Republic of Poland to a foreigner who is a victim of trafficking in human beings, human trafficking. When we talk about the other legal act, the Act of Protection of Foreigners contained on granting protection to foreigners, we have at least 3 different instruments, such as granting of refugee status, complementary protection, temporary protection of foreigners, 3 of them. So as you see, not going into details, but as you see, there are plenty of instruments which can be used and can be fit to almost every situation, in fact, which can be met on the border. Every migrant, every refugee in Poland can find the proper measure, instrument to legalize his stay. Those measures have great procedural guarantees. So in Polish law, we have, in theory, we have a right to a lawyer, we have a right to consultation of a refugee with NGOs who help a refugee. There is an obligation to translate everything. So there is an obligatory access to translator. It is not possible to lead all the proceedings in Polish. The problem is that even if the refugee tries to fulfill the request to legalize his stay or her stay in Poland, due to the fact that we have pushbacks, the requests are not being accepted. And as with every proceedings, there has to be a document which starts the concrete proceeding. And it is the same in here. If the border guards don't take the request, it's not possible to start the proceedings. We have great NGOs, great volunteers who try to help in such situations. We have lawyers who help pro bono to such people, and they become representatives of refugees. They try to start the proceedings of legalizing the stay. But once again, I will repeat it. That is the top of the iceberg. There are not many people who can find, who have enough of luck to be contacted with such NGOs or such lawyers. There was a moment in Poland that Polish lawyers pro bono tried to help in a situation by asking the European Court of Human Rights for interim measures. And in fact, Strasbourg used to deliver interim measures concerning Polish or refugees on Polish-Belarusian border. At the beginning, they were effective, but there's always some but. Someone discovered that if you use this second worse pushback with no decision, there's no evidence that someone was on the border, and there is not possible to find the one who is guilty of using the pushback or activating the pushback. And there were some situations which are known to European Court of Human Rights and were even an object of judgment, in which the interim measure was not effective. It was not obeyed by Polish border guards. That is the situation in which Polish judges try to make a concrete position. We try to deal with the situation. Once again, I will come back to my first remark that we don't, since before 2021, we didn't tackle such a problem as Western Europe countries. For us, the increasing number of requests and increasing number of people who would like to cross the border in Poland with Poland illegally was quite surprising. And I was trying to recall myself the moment 5-6 years ago in which I had a concrete case of a foreigner, and in fact we didn't have many of them. That was really, really exceptional. So also Polish judges were not prepared for the situation. No one, of course, the executive powers were not interested in increasing our competences in this topic. which is quite obvious. We were trying to organize not self-defense, but we tried to self-try. We wanted to organize trainings for judges. We were trying. We also created, in cooperation with lawyers, the special manual, which was called "The Law at the Borderline." Quite a tricky name, but we created such a handbook manual for our colleagues, so that it could help them to adjudicate in cases concerning the migrants, refugees. But even despite those tries, we didn't avoid mistakes and big problems. One of the biggest problem of Polish courts tackling the problem of migrants is that we accept, in general, we accept the motions of the border guards to put the refugee in a special guarded center. All those great instruments that I was talking about have one thing in common. As far as they are ongoing, there have to be given some preventive measures. And once again, I would like to say that Polish, in theory, we have great solutions. We have possibilities to use non-detention preventive measures, but in fact, when the border guards come with those motions are almost in 100% accepted. And that is the point which creates a serious discussion between Polish courts and lawyers who help the refugees. We know that this situation has to change, but still there are not many. We have the problem with conscience that there are some other measures, not only detention, and that's one thing. And the second is that the infrastructure to organize, to use other preventive measures apart from detention, they are really poor. And we are aware of that. So that is another another thing which has to change in Poland. To sum up, because I know that we are running out of time, is that we are aware that Polish solution, that we are living in a kind of a bit schizophrenic reality. We have very good instruments which cannot be applied properly, because still there are a lot of small legal obstacles which do not allow the refugee to come to the moment in which he's able to reach the proper legal protection. To finish, I would like to say that I will leave my presentation to all of you, but there's also a kind of elaborate in which I gave a lot of details about every instrument which was mentioned today. And if you would like to compare whether Polish instruments and solutions are as good or maybe better than Italian, I will leave this elaborate, and I would be happy if someone would like to say it or study it. Thank you.
Grazie davvero Giovanna. Adesso do la parola alla collega.
Thank you, Joanna. Now I'm gonna hand the floor to our Belgian colleague, Isma Belaid.
On behalf of the Association Syndicale des Magistrats. Fatigué, comment on dit? Tired. The audience is very tired, so am I. Thus, I will try to do my presentation and go straight to the point. First of all, I'm very honored to be here to speak about, on behalf of the Association Syndicale des Magistrats, on a subject that we have been very concerned about in recent years, namely the non-execution of judicial decision by the State of Belgium on asylum matters. For those who do not know us, the Association Syndicale des Magistrats is a non-profit association founded in the 70s, composed of Belgian judges, and our association is a member of MEDEL. First point, I have to explain to you. Thus, the heart of my presentations, in the heart of my presentations, I will explain to you the impact of what may have been called the reception crisis of the asylum crisis on the Belgian courts and the impact of it, and the rule of law in Belgium. First point, I have to explain to you who in Belgium is responsible for the reception of asylum seeker. This, the Belgian law has transposes the Reception Condition Directive of 2030, and this law has created an agency that has legal personality, fait d'asile, and this agency is under the responsibility of the Secretary of State for Asylum and Migration, thus under the personality of the government. And so this agency has the obligation to provide material assistance to each asylum applicant. In recent years, with the increase in the number of asylum seekers, fait d'asile has no longer fulfilled this obligation. And as example, since January 2022, applicants have to register on an online waiting list after the application and are then on the stream during the procedure. There were worst periods in the history, but as example, in October 20 and 22, women and children were forced to sleep outside. This situation, which can be described as a humanitarian disaster, forced the asylum seeker to turn to the courts to compel fait d'asile to fulfill its legal obligations related to the material assistance. And this situation caused an explosion of litigations to the courts, especially one court, the Labor Court in Brussels, le Tribunal du Travail francophone de Bruxelles, French-speaking Labor Court. And there were two types of actions in front of that court. Individual urgent actions with also two types, a contradictory urgent procedure of unilateral procedure of extreme urgency without the presence of the fait d'asile during the procedure. And there is also a more ordinary procedure on the merits before the Labor Court, and these actions seek to obtain recognition of the responsibility of fait d'asile and to obtain damages. That is an action ex post. This court has to deal with an extremely important number of cases, and I will give you a few numbers as example that will illustrate the extent that these cases have taken. It destabilized and drowns and disorganized this court. So in 2019, the Labor Court in Brussels received 49 requests, unilateral requests in extreme urgency. And it can be said that over a year, such a number of cases is quite limited. But a year later, this number rise to 1,249 and even reach 6,706 requests in 2022. Become unenforceable, but remain in many cases without any follow-up. So since 2020, and that can be worse. We can say that in 90% of the case, the asylum seekers obtains a decision ordering fail asile to fulfill its obligation. But these judicial decisions are not appealed, become enforceable, but remain in many cases without any follow-up. So since 2020, we can say that about 1,000 of court decisions, mostly taken in extreme industry, have remained without any execution from the state of Belgium. Just as a result of the non-execution of these decisions, hundreds of applicants then turn to the European Court of Human Rights. And in view of the gravity of the situation, the European Court of Human Rights has issued hundreds of interim measures requiring the state of Belgium to execute the decisions. And also, logically, to provide them accommodation, etc., and material assistance to meet their basic needs, and also to provide some dignity to all those people. That's a very strong word. Most of you must know the decision of the European Court of Human Rights in the case Camara against Belgium. This decision use very strong words against the state of Belgium, and they speak about systemic deficiency of the state of Belgium. That's a very strong word. And the court found that this situation constitutes a violation of Article 6 of the Convention. One might think that such a stop would change the situation. But now we have had the feedback from the activities from the Brussels Labour Court, and at the beginnings of this year, the situation remained unchanged and will not improve this year. For your information, there was also several actions of collective interests. The failure to comply to the reception obligation of asylum seekers has also led to other procedures. I will not quote all of them. We don't have the time and the energy. But for your information, there was also several actions of collective interests to obtain the recognition of the responsibility of the state of Belgium. To cancel an illegal instruction by the Secretary of State for Asylum and Migration. To be completely complete, I should also mention the last September decision of the Council of the State of Belgium. That is the highest administrative court in Belgium, which had to cancel an illegal instruction by the Secretary of State for Asylum and Migration, which had decided to refuse asylum to single men. And the Council of State found this instruction to be illegal, as the benefit of material assistance shall apply to any asylum seeker according to the law. And in the press, the Secretary of State have decided to announce that she will not comply to this decision, and that she will persevere to refuse asylum to single men. As you will have understood, the situation in Belgium is such that we can dare to speak of a crisis of the rule of law. that has provoked many outrageous reactions in the academic world, in the associative world. The Association Syndicale des Magistrats has reacted on many occasions on this matter. The bars and many associations have been organized a symbolic ceremony to bury the rule of law. And even the workers of Vedasil, the agency which is obliged to provide the material aid, have expressed their discontent in the press because this has an impact on their working conditions, and they feel ashamed that they are not given the means to their jobs properly at the service of asylum seekers. Another and last example is some decisions in the Netherlands that refuse to apply the principle of mutual trust because Belgium does not respect the principle of the rule of law. What will be the next regression? I will conclude with some thoughts and consideration. You have understood that Belgium has gone very far in undermining the fundamental rights of the asylum seekers. And should I say that we can be afraid what will be the next regression?
Ringrazio davvero Isma. Certo, questa...
Thank you, Isma. Your overview of the European countries is not certainly encouraging, despite what Mr. Di Muro said about, implementing a pact that already makes it difficult on the judges to guarantee the migrants' rights. So we're actually going towards an even worse situation. Now we need to leave the table because we have run out of time, and we need to leave time to the next roundtables. Thank you. Thanks a lot.
Io sono proprio timida, ho paura a dire smetti, capito? Mi sento maleducata, quindi non sono adatta.
Bene, proseguiamo, siamo abbastanza in ritardo, però cerchiamo di continuare. Proseguiamo questa parte con uno special guest che è il professor Gias di Londra. I'll switch to English as I don't know how his Italian is. Bene, proseguiamo, siamo abbastanza in ritardo. Però cerchiamo di continuare. Proseguiamo questa parte con uno special guest che è il professor Gias di Londra.
Okay, so let's try and move forward, even though we have some delay. We have a professor from London.
Here, Professor Just is a renowned expert from the UK in the field of refugee law. He holds a PhD from the University of Cambridge. He's professor at law at the King's College in London in constitutional law and in international refugee law. He also is beside his activity of practitioner, is also of academic, is also a practitioner. He practices as a barrister in London, and he's also a judge in the upper tribunal in the immigration and asylum chamber in London. So having this complete experience in the topics we are dealing with today, we asked him, and he accepted to deliver us a speech on his thoughts on the especially the experience of the UK which went out, as we know, from the European Union. In the same time, is still in the system of the European Convention of Human Rights, experienced a very peculiar intention to resettle migrants in a country in Africa. Migrants, there was an agreement in Rwanda, there was an agreement among the governments that was stopped by the courts in the UK. That is an example that we have also to face while we are experiencing as well the prospect of having relocation of asylum seekers in a country close to our borders, Albania, which is a topic of actuality in our country. I will not take our time. I will give the floor to Professor Just, which is delivering us a speech on the offshoring of refugees, problems and prospects. Thank you, Professor Just.
Well, thank you, and thank you very much for those very kind words of introduction. My Italian, there was a reference to my Italian, which is non-existent. In fact, I come to Rome to learn Italian. I don't have the great luxury of a multiplicity of choice that Sarah, coach at the back, does. So I shall labor on with the Queen's English, or as it now is, the King's English. My talk actually flows very naturally from the last speaker, from Judge Sikora's, with her emphasis on detention being the order of the day in Europe, and how alternative means of trying to use more humane methods of dealing with refugees have failed. What I propose to do is to structure my talk under three heads. First, the state of migration in the world. Second, the EU Pact on Migration and Asylum. And third, the position of Italy, on which I hope you will have more to inform me and to instruct me than I to you. So first, with the state of migration. The rich world is in the middle of an unprecedented migration boom. Its foreign population is rising faster than at any time in its history. So last year, 1.2 million people moved to Britain. Australia has twice the rate of migrants that it did before the COVID-19 boom. Spain's figure is at an all-time high. 1.4 million people moved to Australia, which was a third more than the figure during before the pandemic. Canada has doubled its number of migrants from 2022. Germany has an even higher rate than the migration crisis of 2015. That's the predicament. What does Europe do about this? Well, there have been agreed a EU pact last December on migration and asylum between the European Parliament and what it does, I will not spend too much time on, is this. It actually creates a surge in suffering of the asylum seeker at every level, from the moment that the asylum seeker leaves their country and travels through to their attempting to access asylum procedures at the European border. And by that I mean countries like Italy and Greece, right the way through to accessing safety later on. And it's that which, if it is implemented in its present form, will lead to a de facto detention at EU borders and a substandard system of border asylum procedures, to which I'll come to in a moment when I deal with Italy. And this migration pact also falls short of actually supporting in a concrete fashion the countries that are really at the receiving end of asylum flows. And these are the outer rim countries. Historically, we've always known that before they head off to those richer countries, like Britain, London, where I come from, Germany, France, they enter through the outer rim countries like Italy, Spain, and Greece, rather than supporting those countries with more resources and better procedures. What has happened is that they've left it to those countries to deal with this themselves. So they have not prioritized solidarity through relocations and strengthening protection systems. What they've done is simply to allow those countries to pay to strengthen external borders or fund other countries, like Italy has done with Albania with its recent deal, and to prevent the EU from having to deal with this as a collective body themselves. And that allows countries to opt out of a broad range of EU asylum rules, and that's the problem. So in times of increased risk or increased arrivals of people that I've just referred to, it allows countries to opt out of those protections that we're all acquainted with. And this agreement, therefore, reinforces the EU's dependence on states beyond its borders to manage migration. Now, the Italian deal is the first deal of a European country with a non-EU country, namely Albania. And that's what, if Italy gets this right, it will actually be a model that other countries can follow. And my misgivings, with what knowledge I have, is that it's not going to get it right, but you tell me. But if it gets it right, then that's what other countries want to do. And what they do is to attempt to manage migration through deals with Albania, Libya, Tunisia, and Turkey. And the problem with that is that rather than investing in a dignified reception within the EU and expanding safe and regular pathways to allow people to reach protection in Europe without relying on dangerous journeys, what we're going to get is the externalization of border control. What we need to be doing is to be putting human rights at the center of negotiations on EU asylum reforms. What we are instead doing through underinvestment in asylum and reception systems is an unlawful and often violent pushback policies which deny people the right to asylum. I only have time to really sketch the EU Migration Pact in this fashion. We'll have to wait and see how countries adopt this. I will now go on to Italy. Now, when I look at Italy, I do so on the basis of my own involvement as a lawyer in the Rwandan case, where the British government actually faced a defeat before the courts. Since then, what has happened is, of course, that the Italian deal with Albania has also come to fruition. And it's in the light of that I have come here to talk really about the future of such policies. And here is what I have to say. In the last year alone, 3 deals have failed. There is the EU-Tunisia deal that failed in April 2023, struck down by the courts. There is the British-Rwanda deal that failed on the 15th of November 2023, which, as I say, I was involved. And there is the Greece-Albania deal, which was struck down on the 13th of December 2023. Denmark has also adopted a model that is not working. And the problem here is this, as the German government itself said, it's actually very difficult to find countries that are willing to establish reception centers to which we can send our unwanted refugees. Really very difficult. The Council of Europe on top of that. So that's the practical problem. But there is also, in addition to the practical problem, the ethical and legal problem. And the ethical and legal problem is this. The Council of Europe has said that there is a worrying trend of externalization of asylum responsibilities. That simply is legally unsustainable. You can't go along with this. And a very good example of that is the case of Ilias versus Hungary, which establish that state parties like Britain and Rwanda, like Italy and Albania, cannot remove people to a third country without first inquiring as to what that third country is doing. What is its track record? How have they dealt with? Now, with Italy and Albania, there has been an existing deal between Albania and Greece. That is not working. And therefore, for Foreign Minister Tajani to say this is what we're going to be doing begs the question, have you looked at what it is that is actually happening there? because when the British deal was struck down by the British courts, what the British court said was this, that there was a deal between Israel and Rwanda that for 5 years, from 2013 to 2018, led in 2016 to an Israeli constitutional court decision to the effect that the Rwandans were actually returning people to the very states from where they came to be persecuted, and therefore the deal wasn't working. That was a decision by the Constitutional Court in Israel in 2016. What does Britain do? Ignores it. And you can't. And could I just see my overhead projector, please? Since we have lawyers present, could I just make the following clear to you? This is something that we have all learned as law students, as others, and this is the separation of powers doctrine, because what's happened now is this. The Rwandan deal was struck down by the British courts, and the British government, through its executive, I mean, Aristotle spoke about 3 different kinds of dictatorships, and one of which he said was the benign dictatorship. In 1977, our Lord Chancellor in Britain said that in Britain we have an elective dictatorship, which was actually the most benign dictatorship that Aristotle referred to, because once you vote the government in power, they can pretty much do whatever they like. They're elected, but they're an elective dictatorship, and they're the most benign. And so what's happened is the British government has come back with a vengeance, and they've passed a law to say that actually we have passed a law that Rwanda is a safe country. So through a conclusive legislative fiction, whereas the courts have found that Rwanda is not a safe country, the British legislature says, no, 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 it is a safe country. Well, you might as well say that the moon is made of cheese, mightn't you? All right, and here's the question. What we all learned was this, wasn't it? That it is for the courts to find the facts and for Parliament to make the law. What happens when Parliament makes the facts? What happens? What happens if, for example, this deal that Italy has now negotiated with Rwanda ends up coming before the courts because some asylum seeker says, actually, my rights are going to be jeopardized and I'm challenging it. Do the courts say, no, 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 actually, Parliament has told us what to do? Well, look at that. The separation of powers doctrine, Montesquieu said that this was the ideal form of government, and he pointed to Britain as having it. He was wrong. Britain didn't have it, actually. But what it says is that there are 3 spheres of government. There is the executive, there is the legislature, and there is the judiciary. And that's the problem. The problem being this. If in the first circle you have the executive predominating over the judiciary and the legislature, what you get? Dictatorship. If in the second sphere you have the legislature predominating, and all this talk now, and it was all behind Brexit as well, wasn't it? Oh, parliamentary supremacy, the British Parliament is great, and so on and so forth. If you have the legislature predominating over the judiciary and the executive, what you get? Dictatorship. If you get a juristocracy, the judiciary, predominating over the executive and the legislature, what you get? Dictatorship. And of course, those 3 circles, you can manipulate them in whichever way you want. In Iran, you have a theocracy, don't you? And that predominates. In Myanmar, you have a military government, and so you've got that predominates, and the courts can't check it. So what should the goal be? The goal is as follows. The goal is where the executive and the judiciary and the parliament are in this tense and quite competitive competition with each other. But they are respectful with each other's domain. Sometimes, of course, as my bottom circle shows, the executive will try to push the judiciary outside. But the judiciary just has to fight back. Because if they don't, what you get? Dictatorship. And this is a problem with populism and so on that we're all facing in advanced democracies. I was recently reading an article that the Republican Party in America is trying to create America into a theocracy, into a religious state. But again, look, the facts matter. The great thing about the courts is that judges find the facts. The facts matter, and every time Trump has come through, the courts have said, no, you're wrong. We have to find the facts, and on the facts, you are liable. And the same happened with Britain. When Parliament was prorogued by David Cameron, he wished to pass through the Brexit legislation, the court said the prorogation was wrong. Right? Normally, you'd suspend the Parliament for a week. He suspended it for 5 weeks in order to get his Brexit through. And of course, the courts came in and said, no, on the facts, you haven't made out a case. And again, with the Rwanda case, they said, look at the facts. And the facts are these. You see, in Rwanda, the only experience they've got of asylum seekers are people coming from Burundi and the Congo. They have zero experience of European asylum seekers, which are Iranians, Afghans, Yemenis. Rwanda has refused 100% of Iranian, Afghan, and Yemeni refugees. Britain has allowed 87% of Iranians, 74% of Afghans, and 30% of Yemeni. I mean, there is no comparison. When the court looks at that and says, how on earth are European refugees going to be dealt with by the Rwandans? And the court also refers to how it was that in 2018, when some refugees in Rwanda went on a food strike, they were shot at by the Rwandan military. I mean, there is simply no understanding of non-refoulement and the like and so on. So that's what the courts looked at. Facts matter, and none of those facts have been looked at by the legislature, by the government. So that really is something which, as I say, we learned during our school boy days, but vitally important, and we mustn't forget it, because if we forget it, we end up in a dictatorship. So I have still 15 minutes left, and let me go on to speak about Italy then. So what has happened is this, that Italy has, of course, negotiated a deal with Albania, and the Italian protocol is actually a very ambitious one. It aims to build migrant camps in Albania, and it's the first ever deal, which will involve a non-EU country with the responsibility of accepting migrants on behalf of an EU member state. And the idea is to offer migrants the option of having their asylum claims determined in an allegedly safe third country outside of Europe. Now, a record 150,000 migrants came by sea to Italy in 2023. And the year previously, in 2022, only 94,000 came by sea. So clearly, Italy is facing an upsurge of refugees. And how many of those were Italy able to return? Just 40,000. Wasn't really able to return very much. So under this Italian protocol signed in November 2023, the Navy and the Coast Guard vessels are to be intercepted, to intercept migrants in international waters. They are to take them to Albania, where they are to be placed in one of two facilities which the Italian government will build in Albania. First, migrants will first be assessed at the popular seaside resort port of Schengen, and then they will be taken to Gajeder, which is 15 miles inland, where they will await their decisions at a much larger facilities, and that will be constructed on a disused Cold War military airfield. If the migrant is successful in the asylum claim, they will be brought to Italy. If they are unsuccessful, well, if they're unsuccessful, then what? If they're unsuccessful, do they get detained by the Albanians? Or do they get returned back to their own countries? Or do they actually fall victims to human traffickers and end up being whisked off to Croatia? Do they find a backdoor way into the EU anyway? And if we are to avoid all of that, and the idea is that the unsuccessful ones will come to Italy, well, hey, hang on a minute. Isn't that the same as successful migrants? Because the successful asylum seekers are already being accepted by Italy. So if the unsuccessful ones can't be kept by Albania, do they also come to Italy? Right? You can straight away see it's not very well thought out. Okay, so, and the other thing is this. What is being suggested is this, that the requests for admission are to be speeded up within 28 days. So the Albanian government is to process this within a month. Italy is already, like Britain, taking many, many months to process an asylum application. What basis do we have for thinking that the Albanians are going to do this within 28 days? And then if they are refused, they are to be promptly dispatched to their country of origin. The 2 reception centres are to be up and running by early 2024. We are now in April, and you will know this better than I. Have they been built? Right? And they are to be built, and they are to accommodate as many as 40,000 asylum seekers per annum. Italy has already paid, as Britain has. Britain paid £240 million, and the only person who's been able to go to Rwanda is the foreign secretary on an aeroplane. That's good value for money, taxpayers' money, my money. Now, for the Italians, this has cost 16.5 million euros. But actually, from what I know, the figure is much higher. It's 300 million, and it could escalate to 900 million. Okay, and at the moment, as I say, we don't know whether the reception centres have been built. What Foreign Minister Antonio Tajani is saying is that once the Italian Coast Guard or Navy has intercepted the migrants in the international waters, then Albania will have sent these will be sent to Albania, only those who have no right to remain in Italy. And that Albania would not have any children sent, and not have any pregnant women sent. All right? Okay, now, here are the potential problems where the courts come in. You can see how this is going to be challenged at every level by clever lawyers who are acting for asylum seekers. Firstly, what happens if the failed asylum seeker is rejected in Albania and whose country refuses to admit them? As I said, only 4,000 of the 150,000 entering Italy in 2023 ever returned home. So if Italy will not take the failed asylum seekers, will they be subject, as the last speaker, Judge Sikora, was saying, will they be subject to indefinite detention in Albania? The lawyers are going to be saying this is a violation of their Article 3 human rights to be free from inhuman and degrading treatment, and straightway you've got a challenge before the Strasbourg court. Second, what happens if the procedure is not done within the stipulated time of 28 days, and it's much, much longer? Is there a basis for saying that if it takes longer and longer and longer, during that time the person is detained? Do they then bring a claim? Thirdly, what will happen to an unsuccessful asylum applicant who the Albanians cannot repatriate to their own country? I've already dealt with that. Do they become the responsibility of Italy anyway because the Albanians can't repatriate them and they're unsuccessful? Fourthly, what if Italy refuses to have unsuccessful migrants repatriated to them from Albania? Are such migrants to be subject to indefinite detention? Fifth, and if they are not to be locked up as unsuccessful asylum seekers with no right to remain, do they then proceed to another European country in the north, like Croatia? Sixth, if that is a scenario that is likely to unfold in this situation, is there a risk that you are going to get human trafficking taking place? All right. Human trafficking is up there with the big three as the major global industry, up there with arms trading and drug dealing. It's the third highest revenue created in the world. It has really mushroomed. Okay, so those are the practical problems that will lead immediately to challenges. There are, secondly, ethical problems. The ethical problem is the Council of Europe has said that this is another example, that the Italian example is another example of, quote, a worrying European trend towards the externalization of asylum responsibilities. And I think this is a challenge. I mean, I really do think the numbers are up. They are increasing. Unprecedented boom, really. Are we going to get support from the central organs, from the European Parliament and so on, to really deal with asylum seekers in a dignified manner? If not, then what are these countries like Italy and Greece to do? Can they really have in place a system that is ethical, that is practical, that is not subject to challenge, which can be, if you like, a model for the future. Because if it isn't, then you will get that opposition from the Council of Europe that this is a worrying trend towards externalization. I can tell you that the British government has thought, well, look, Labour government, I spoke to somebody there, incoming Labour government is thinking, if we can send them to a British colony, but the British colony like Belize in Latin America is too far away, right? I mean, how do you send them all the way across the Pacific to South America? Rwanda is too costly. So you could send them to a place like Belize, which is a British colony, which you could say is a model. Because you see, the other problem with Italy is this. Tajani has said, oh, don't worry about this. Although this is Albania, Italian law will apply. Our people will be there. No. Italian law doesn't apply there. EU law doesn't apply in Albania. EU law only applies in the EU. So actually, only Albanian law will apply there. The thing about the Labour Party's proposition is, at least in Belize, British law will apply, okay? But then look at the cost. I mean, it's going to be astronomical. Okay, so that's the problem there. I should just say a couple more things, 5 minutes left. Edi Rama, the Albania's prime minister, earlier said, and this comes back to Germany saying it's very, very hard to find countries. Edi Rama said earlier, he said, look, Albania, our country, is not a country for the EU to dump its desperate people like toxic waste. He said that refugee camps would never be built in Albania for use by the European Union. Now, such condemnation from the Prime Minister of Albania must mean that it cannot be assumed, even now, that those reception centers, even with the payment of 16.5 million, will be built. I wait to be proven wrong. That's the first thing. The second thing is this. Look at the country we're dealing with. It's just like Rwanda. Albania is like a third world country. It is actually a refugee-producing country itself. All right? It is a country that largely Muslim population coming out of the shadows of totalitarianism during the Soviet regime, and they had in 2015 lodged 54,000 claims for asylum in Germany alone. That's in 2015. All right? And their cases are all to do with human trafficking, with blood feuds, with expressions of sexual orientation, gender identity, and domestic violence. They produce amongst the most vulnerable claimants coming to Europe. And yet, Italy is doing a deal with that country. Okay? So as I say, it comes back to this problem about can you make it work? And that's on top of the ethical legal problems that have not gone away. I've come to the end of my time. Thank you very much for your patience.
Thank you very much, Professor. Thank you for recalling all the problems, the juridical problems we are facing, because my impression is this morning we are talking of all fictiones, you know, we have a fiction of a safe country, a fiction of not entering Europe, a fiction of non-detention, a fiction of non-deportation. Before we make the album Negro, still it's very, very difficult to get, especially when we deal with persons in difficulty. I think we finished this slot. Thanks a lot indeed for coming, accepting our invitation, coming in Rome. It was absolutely interesting for us, and I will give the floor to the next, alla prossima tavola rotonda. Vabbè. Senza pausa. Grazie.
Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Allora 10 più io me ne basta che mi siete metti qua, vai. Chi? Lei? Vai. Da fianco a Papi. Fianco a Papi. Io sono ciao. A fianco a Papi. Va bene.
Allora iniziamo questa tavola rotonda, non è una replica quindi possiamo tranquillamente partire dalle acquisizioni delle belle relazioni che abbiamo sentito, anche dagli interventi sofferenti, diciamo. Vado? Sì. Allora iniziamo questa tavola rotonda. Non è una replica.
Let's start this panel. This is not going to be a double the previous one, and certainly we will draw from the previous speeches. And we know there are so many rules, pages and pages of new rules with many following documents. Also, upon request on our friend that you certainly know, Emilio, he says that the European Commission has already sent a communication in which they say that member states should remain in a pre-alert state, because in June there will be one of the EU Commission guidelines on the pre-implementation of the Migration Act, with specific instructions and studies on third countries that can be helpful for the national legislators. And subsequently, there will be these 2 billion euro made available for the organization and implementation of the instruments for the reception, which are clearly not sufficient. Yesterday, I was on a plane and I read another communication by the European Commission dating the 12th of March, striking a balance on migration approach, which is both fair and firm, which is really incredible, because in 22 pages, it never uses the term fundamental rights, and not even human rights. I remember that despite the European Parliament resolution on the enlargement, but the European Union has to comply with its own charter, and the EU Charter covers the fundamental rights, not the human rights. But it is quite a worrying document, because in it the Commission, in describing this mega future legislation, which will be launched in the next few days, and but never mentions the fundamental rights. I agree with Professor De Muro, and certainly during the negotiations, the European Parliament has introduced some limitations, and certainly these are things that are important within the EU, because the EU is governed by the rule of law, the judicial verification, and the Court of Justice recently said many important and stringent things, also in accordance with the Charter of Strasbourg. I would like also to mention the Grand Chamber sentence relating to the ex officio verification of the repatriation orders. And an important thing was said within the European integrated legal system, that is that the judges are actors that must become the protagonists and the creators of the rules of the EU law, that this is an invitation to the systematic disapplication of the rules in this subject matter, just like also for the consumers' rights, and also the assent of the Court of Justice dating 8th of March 2022, which was a breakthrough relating to the direct powers of the national judges to fail to apply all the sanctions to penalties that can be imposed also ex officio. There are 30 directives which were involved by these huge powers. And I am sure that this operation should be carried out. I mean, using all the possibilities that we have been given by the European Parliament, as Mr. De Muro said earlier. But we need to say that the 10th of April was really a day when there's a harsh fight, because the EU really rebelled, and the poor NGOs, which are under attack in all the national states, and in order to perform the duties they gave up on general narrations, and they are dealing with civil services. But this time they just protested, and the result on the vote of the European Parliament has been there because these texts were approved with, in many cases, with 20 votes. And for a negotiation lasting 5 years, this doesn't seem much. So there's a sentiment of insecurity vis-à-vis the protection of fundamental rights. We can read that there are some rules that we are going to embrace. And so before I leave the floor to our speakers, I would like to emphasize that we have two problems. On one side, we have to set up combined task forces, including lawyers, jurists, professors that are follow the process indicated by the Commission, because we don't have to wait for 2 years, because the future starts in June. And so this implementation process should be consistent with the preambles that have been made by the European bodies in terms of protection of fundamental rights. On the other side, the no authorization of the public opinion, and they could lead to something. Probably, I'm not saying that the legislative process will be reopened, but there should be a sort of a monitoring of monitoring. I mean, at a certain point, maybe a European conference will be summoned, and there will be the States General of Migration before even the accomplishment of all the processes. We should have the opportunity to valorize, to have a common action, to implement a common action, so that we can set some limitations, set some boundaries in order to integrate the narration of the EU. which certainly is not as valuable as other measures that have been implemented over the few months by the European Union. This hasn't, for example, the power of the directive on artificial intelligence, which is about the human control on the Gen AI processes. And so they managed to do what no one else on the planet managed to do. And also from the initial directive on minimum wages, also developed a due diligence directive under which the employers are forced to monitor the respect of human rights also in the related supply chains. So they should monitor the suppliers from all over the world. But this one here is a weak directive, and the civil society must be involved, and we must work accordingly. I had prepared another topic, and going just to say briefly that we need to have a counter narration in order to fight against the technical impact. I think that this could be represented by the narration that we had.
L'infinita produzione che ebbe negli anni 90 e 2000 non partiva da un approccio alla fine pragmatico, nel senso che noi non possiamo negare l'importanza dei confini. Non la nega Navy Bar quando ci dice che i confini sono il fondamento antidemocratico delle democrazie. I popoli sono abituati a governare attraverso i confini, a riconoscersi, a avere delle identità. E se poi uniamo questa, però qual è quindi l'obiettivo? È di renderli dialetticamente negoziabili, di renderli permeabili, di attenuarne l'impatto. Ora noi non stiamo procedendo a questa direzione, ma il suo opposto. Del resto, se questa narrazione la integriamo col magistero vespasiano, d'altra parte l'Unione Europea si è già strutturata come una cittadinanza di solidarietà tra estranei. Già l'idea dei confini all'interno dell'Europa è stata abbattuta sulla base della possibilità di acquisire un demos democratico che non si fonda sulle identità escludenti derivanti da tradizioni, da cultura, da cultura no, perché esiste una cultura europea, da altri fattori prepolitici. Quindi questa contronarrazione la dobbiamo recuperare collettivamente, cercandola di porre come strumento e come veicolo argomentativo anche sul fronte dei diritti fondamentali e di apertura ai cosiddetti paesi terzi. A questo punto io inizierei questa tavola rotonda in ordine, diciamo, della lotteria naturale, cioè quella del cognome, e darei la parola all'amico Franco Ippolito, presidente della Commissione. 10 minuti, Franco. Sei in lotta con un panino, ricordo. Allora ancora è una lotta ancora più feroce e unfair, diciamo.
Che è stato, come dire, rilanciato. Io ho esercitato giurisdizione per 45 anni e quindi non posso rimanere ovviamente la riscrittura indifferente all'invito che faceva prima il rappresentante dell'UNHCR, che è stato, come dire, rilanciato dal nostro presidente Giuseppe Bronzini, che affida ai giudici, ma poi quel segmento va inquadrato in un la riscrittura complessiva dell'ordinamento giuridico in materia di migranti, tenendo conto che il legislatore formula pezzi del sistema, segmenti, ma poi quel segmento va inquadrato in un sistema più ampio che è fatto di altre norme
other provisions, of other priorities, of hierarchy of laws, of treaties, and Charter of Fundamental Rights. With the due respect given to the vote at the European Parliament, we cannot but speak of these issues. As Aguilar was saying, we need to take into account compromises. I have worked for 45 years as a judge, but I am not a judge anymore. But today I represent just a share of civil society as Basso Foundation, and this gives me some possibility to have a voice. And I remember when I was young, and when I was starting taking into account complex political issues, I found a quote by Pietro Nenni, who said his party members, when you do not understand the situation and when you are not able to orient yourself, read the newspaper Corriere della Sera. Many years ago. So you understand the opinion of journalists, the opinion of Giulia Crespi, and when you take into account their opinion, please believe the opposite. So if we consider, I've always considered Pietro Nenni a big wise man in politics, and I say to President Lopez Aguilar, dear President, when I see that the Italian government and especially the Ministry of the Interior, Piantedosi, when I see them enthusiastic about this pact that was voted by the Parliament on the 10th of April, if we remind that the Italian government issued Cutro decree, and the Ministry of the Interior was also involved in Cutro decree, like irresponsible parents that take on ships their small children, then I start using Pietro Nenni's quote, and one thing that Minister Piantedosi likes is also something that I think I hate, but also the majority of people hate here, as well as the majority of people who are listening to us. So I think that what comes out is a strengthening, a rationalization of a system that sees in migrants a danger for the boundaries, for the public order, and it is very far away from being able of reconciling obvious security needs, safety needs, with an idea of migrations as resources that are useful to the world, to Europe, and to Italy. So it's not a chance that even though responsibility and solidarity are taken into account, the economic resources, the financial resources that come from compulsory solidarity of those who do not want to support, to help these migrants, how will these resources be used? They will be used in order to strengthen the defense system of boundaries, whereas a small signal might have been strengthening the reception system in the different countries of the EU. I do not have much more time to speak, but I would be tempted to use the minutes I still have to read you an interview that yesterday a European deputy, Pietro Bartolo, gave to the newspaper Manifesto. And I read you only the title. I quote Bartolo, we have given a legal appearance to everything that today is not legal. We have legitimated it. So in Bartolo's words, there is a pretense, but there is no pretense when Bartolo says, I have become a European deputy and I want to take care of migrants. Today, I feel I should say that I have failed. And I think that together with him, we have also failed. We and all of those who have always been committed to find a unity for safety, for rights, and for justice. The other day, while I was thinking about my speech, I had something in mind. We, as legal experts or judges, when we started to discuss about these topics, the first conference that we did was in Turin, northern Italy, in 1989. It was spring, summertime 1989. Then Franco Angeli wrote in 1991 The Europe of Foreign People. And starting from the first pages of that book, all topics could be found on which the public opinion discussed and has discussed over the last 35 years. Everything concerning migration that could not be blocked or materials 2,035 kilometers all over Europe. So the long range of migrations due to demographic changes in Europe and Africa and also other causes causing migration. There is no irresponsibility. So there was no irresponsibility of parents trying to find for their children a place where to live and not to survive when everything goes well. So the lack of policies that are able to manage the migratory flows that causes and multiplies the lack of xenophobia, fear, racism, among others. And then in the end, there is a wrong use of social fear for political consensus in order to cover some inability to face the big crisis. So when that book and that premise are read, so after reading that book, I felt discouraged because I thought that after 35 years, and we were not the biggest ones, the greatest one, the greatest. We were not the most long-term viewers, let's say so. But we need to say that after 35 years, we have not been able to change a slight appearance of common sense. So if we consider the statistical data that Ilvo Diamanti gives us with his researches. Well, probably among legal experts, we might say that all speeches on humanity, the memory of Italian migration to North America, to Northern Europe, cannot change the common sense of people. So if we want to be witness of a civilization of the European law, but also if we want to reach some results, I think that we should at least try and change the narration, not only in order to go against the narration Giuseppe Bronzini was talking about, but we should also, I think, use not only law and politics, but especially demography and economy. And I think that the main role is played by the press. So this is why I would like to invite all organizations that promoted this conference that should be addressed mainly to the press and to journalists. Demography. First of all, some small books were published. They were small and precious. One of them is at the bookstore from already now today. It's the book is called Chiusi Dentro, so closed inside, considering the confinement camps in Europe, starting from Schiavone and starting with the introduction of the book to the book, but also a book called Governing Migrations by Ferruccio Pastore and Livi Bacci, demographer. So I have quoted these books because I want to stress the need to take into account the fact that at the beginning of the 20th century, Europe had accounted for 25% of the global population. Africa had slightly more than 8%. In 2050, so in 25 years from now, Europe will only have 1/12 of the global population, 703 million, while Africa will have 25% of the global population, which is the population of Europe at the beginning of the 20th century. These data are very macroscopic data that might also speak to distracted journalists, which is the problem that describes how systems are interconnected to one another and influence one another. So if we consider this population discourse and if we add it up to the composition discourse, this composition of population discourse, then we have a country like Italy, which is the oldest country in Europe, and today, the Italian Institute for Statistics foresees that the 3-to-2 ratio between those who work and those who are retired will become 1:1 relation or ratio. So by 2050, nobody will be able to pay for pensions. So should we really add up to a rights discourse, the discourse of welfare, not only welfare for migrants, but also welfare for local people. There will not be any chance anymore to get a good welfare without the fundamental help of migration. And I will close my speech by saying and by remembering what a judgment in 2017 said at the Permanent Tribunal of People. Migrating is, and I quote, migrating is an existential act. The ius migrandi, the migration law that Europe invented to legitimate the conquer of Americas and also the genocide of Indios, is now not worth anymore. But what we still have is the human right of this millennium and the fight that all of us are called upon to fight in order to follow that direction. This fight is similar to the fight for the abolition of slavery. And let's remember that the abolition of slavery was reached not because of humanitarian goals or because of equality issues or dignity or freedom issues, but those were reasons and interests, economic interests, that became decisive to abolish it. So I think that together with rights, we should also use a demographic and economic reason and narration. Thank you. We will talk about it in the next roundtable. We have now the next speaker.
Well, first of all, let me thank Medel for organizing this meeting and especially for doing it here at the University Roma 3 in a department where I teach. And I will really try to be brief, also because I've been involved in the session on civil society, so I will not have a technical presentation, but I know also that the academia must be able to develop critical thinking. I will try not to repeat things that have already been said this morning. I will talk about something that a few newspapers have reported. I see a journalist from Il Manifesto, which has reported it a few days ago, on April the 4th, during an operation of the Mare Ionio, humanitarian vessel, a Libyan boat for the control of the frontiers opened fire against volunteers in order to prevent them from rescuing some migrants whose ship had shipwrecked. And so these migrants just fell into the sea and tried to escape capture in order not to be brought back to Libya. We have to remember that borders have guards and guards have weapons. And right now there is a war at the borders. These images testify of the violence at the borders and of a fight in which men, women, migrants are just putting their own lives at risk against these guards. So they're just helpless against them. And I would also like to say that at the same time, these images are not saying that the freedom of movement is an illusionary thing, but they just mean that right now the freedom of movement of migrants should be claimed as a political concept. This is necessary unless we believe that Europe can build its own freedom on for the price to the cost of other people's lives. Of course, we can't expand this topic, but we have to say that the freedom should be something that is for everyone. Otherwise, it is not freedom. And that's what we are saying here today. And also the need to reverse perspective on the freedom of movement was at the basis of the constituting project of a new notion of European citizenship, Maastricht, Tampere, etc. It is true the freedom of movement within the EU was the strength, the point of strength of European citizenship. It was reserved to some, but it had an expansive force. And we should not forget that this brought about the largest enlargement ever. And Europe actually got enlarged, and this was true on one side. On the other side, there was a functional logic. And nowadays, the freedom of movement has become something different. I'm quoting Kylian Mbappé. The borders have become places where organized violence divides different human species according different classes of computability of risk. For some, crossing a border can be done simply by showing their passport. For others, and the principle of security and safety, of living safely, of acting according to one's own wishes is at the basis of every political organization. But for some, this security and this safety does not exist. It is the need to take risks, to take the risk of crossing the borders. Why am I quoting Kylian Mbappé, who's a philosopher from Cameroon? It's very important today. That's because we need to decolonize these borders. It is not true that the freedom of movement has to do is something accidental. These countries today are forced to implement a border regime, which we didn't know. I would like to say many things because, why this freedom for the price of 30,000 people that lost their lives along the Mediterranean? But we should also include other victims, the victims of the desert. Today, we haven't remembered the violence at South Emilia, once on the Canarian routes, that has become a deadly route, and also a route where Europe plays with commercial relationships a violent role. I'm talking about commercial agreements because right now Frontex is also controlling the fisheries made by the Senegalese with wooden canoes, while we Europeans have agreements on fishing with the so-called farm ships. I think that this freedom of movement should be claimed as a new principle constituting Europe. And we should also remember Luigi Ferrarioli, who talks about this, but also two more things. The freedom of movement is possible. The Ukrainian crisis has explained this to us. In 15 months, we have received and welcomed 5 million people. The crisis of refugees of 2015 involved 1 million people, but we also talked about Albania. On the 7th of March 1991, 27,000 people landed in Bari and they were received. So this can be done. I have 3 concrete proposals now, and then I will conclude. The first proposal, because the freedom of movement for us jurists must be something concrete, and that is the package of facilitations and that hideous crime that legalizes the flight. Franco Ippolito reminded this to us. The Fugitive Act was the way through which they kept slaves in plantations. And it is also the flights of the slaves that made it possible to abolish slavery. So the regulation has nothing to do with any purpose of profit, so we can't criminalize these migrants for crossing the borders under the Cutro decree. There are 100,000 people that have been detained for smuggling offenses. We're not talking about traffickers, but of a different offense, which is an offense that should be abolished. We should also abolish the administrative detention of migrants. This was said this morning. I'm saying something more because I also talk from the perspective of the feminist theory. The borders do not just regulate the entry of migrants, but their very lives. The confinement has become the way in which the migrants are coercively brought back to live their lives. Layers populations. We're no longer building schools or hospitals, but refugee camps. Are we externalizing them? Well, also in this case, probably we should restart from the abolition of administrative detention. And it looks like, even before listening to Daniela's presentation, it seems to be a duty for us. Thirdly, we also need to organize a campaign to enlarge the access of citizenship. This was an old dream of those years of that time, thinking about European citizenship that shouldn't go through the national citizenship. Something very broad, because every child born in Europe has a right to citizenship. In conclusion, I think that migrations create conflict not because they invade us, but because they reverse the order of privileges, of races, of hierarchies, and of classes. This is what is worrying, not the invasion. And what accompanies the freedom of movement is a concrete utopia, but it calls for the legal imagination, the legal creativity that we need in the turning points of the law, as a very important internationalist said recently. So we need creativity, imagination. And I think that this creativity can be developed as of now. Thanks a lot, Enrica. I should say that after June, we can write a document that makes these proposals operational. I'm going to hand the floor to Filippo Miraglia from Arci. And I would like to underline that this panel is against the Green Deal because it's very hot in here. So the floor goes to Filippo. Thanks a lot for your invitation. Thanks to Medel and to Magistratura Democratica for inviting me. I would also like to invite you to organize other such events, because there was really one of the most interesting ones to which I've participated over the past few years. We always have a lot to learn from the things that Magistratura Democratica organizes, and it is very important. The jurists and magistrates meet with the civil population. I have a few topics to touch upon, and I would like to start from this one. The reason why the European Parliament approved this new pact has got nothing to do with what happened in the past, because in the past they've been trying to change the legislation many times. And every time the parliaments make reforms of migration, I'm always very worried, because all the reforms are always depriving them of some rights, and this is the case of this one. And that's why I can't understand why UNHCR is so enthusiastic about this reform. I'm sorry, but I say that from the very beginning when I read the post by Filippo Grandi, I was really amazed, because actually this is a measure that is electoral. They just did it because of the elections. They aimed at this and they were successful, but they just made it with a few additional votes. And this is also our achievement, because for months we've been going after the MPs in order to encourage them not to vote for that pact, because it is shameful, it is scandalous that big European Democrat families should approve something that has only got to do with frontiers. So the European Parliament are giving up on managing migration, but they only deal with stopping people at the borders. But this is not everything that is needed. You also have to allow people to travel. I am one of those who said that the frontiers are not the bad things. We cross them, we have no problems. It's the others that can't. And these governments in the past few years have been trying so many times to have a reform, but never got an agreement on how to let people cross frontiers legally, especially the masses of people, I mean, and not the engineers working for specialized labs, but the ones that arrive in Europe to request asylum and to look for a job. These are most of the people that cross the borders. And for these people, Europe gave up on regulating their circulation. And as we have written and read so many times alongside von der Leyen and the European Commission, the ones that are celebrating this are the ones that have profits from the fact that we prevent people from crossing the borders. So these people will create ways so that they can be paid more by the people that are filling the countries. We were talking about the Cutro occurrences. The ones that came to Calabria were Afghans coming from Turkey, where we sent them under an agreement with Erdogan, and Erdogan is sending them back to Afghanistan. This is why people are fleeing. They have two options. Either they go back to Afghanistan, or they pay to be put on a makeshift boat and risk their lives. And Europe, which in 2023 received more than 1 million asylum applications of illegal crossings and people coming to Europe to seek asylum, there are hundreds of them. We are among those that signed the protocols of humanitarian corridors. But on the other side, they're forced to be in the hands of people taking profits from these illegal crossings. And the parliaments didn't deal about this, but they only dealt with blocking people at the frontiers. Since there is a jurisdictional control, and parliaments cannot stand this anymore because they're very bordered by it, so they modify the legislation so as to avoid that national and international courts make them accountable for what they do, just like what happens at sea with the sentences that are always in favor of the NGOs, especially when we go in front of a court and say that governments are not complying with the laws. Over the past few years, I've been a little bit less optimistic than Enrica. We've lost many battles. For example, in 1989, the first anti-racist event was 7th October 1989. More than 250,000 people took to the streets in Rome after the murder of Jerry Maso. And at that time, the anti-racist movement was taking to the streets with lots of people. There were many demonstrations since then. Today, if we try to organize an anti-racist demonstration, we're not going to have more than 1,000 people on average, maximum 10,000 if we are helped by the trade unions. In 1989, there were a few hundreds of people of foreign origins in Italy, but in the public representation, they were more present. Today, we have more than 5 million people coming from foreign countries in this country, but none of them takes the floor on this event. Just think about it. Have you ever heard a refugee talking about what has been done to refugees in the European Pact? I've heard none of them, and this is quite a disaster. But today we are weaker than ever. I spend a lot of my time doing this, trying to work together, trying to create as many coalitions as possible. It's becoming increasingly challenging and difficult because we're all very busy. And so I have colleagues that know me, and they know that I dedicate a lot of time to the coalitions, but really struggle to mobilize the civil society against the interventions of parliaments and governments. But I think that there is no other way. We cannot wait for somebody else to come and solve our issues. I think that we can just try and practice in front of the tribunals, but also in the taking to the streets, and also every time it is possible with institutions to just try and reduce the damage. But since we have people behind these events, it is important to try and make a change and make a difference, because with a few exceptions, in Italy and Europe, we've always tended to, to subtract rather than to add, so to reduce the rights rather than to adding other rights. So the European Pact doesn't program anything. We can't afford this. We need to enlarge the coalition of civil society and working together to reverse the direction both of the public discussion and also decisions that are made.
Tra le ruote dei governi e dei parlamenti tutte le volte che è possibile, io penso qui veniva detto questo.
So I think, as you were saying, that we will carry out the civil monitoring. We will be also at the borders wherever possible, as well as in detention centers, so that they can be closed, even though such an important political change is difficult to occur over the next few months. Thank you. Thank you, Filippo. Some very important hints. Then I would like to give the floor to Nicola Marongiu, coordinator of the Italian General Confederation of Labor. I would like to thank you for the invitation. We should also have the participation of our secretary, but I would like to raise 3 considerations. The first one is of political nature. Our moderator, Bronzini, highlighted a Wellman regulation but also we might also mention different directives, for example, the one on salaries, the one on environmental sustainability, etc. They have been part of the work of this office, of this legislature, of this period of office. From the point of view of the social impact, some measures were concerning these topics, but there are also some concerns about migration, because we, as civil organization, civil society, political bodies, or scientific bodies, or trade unions, we should ask ourselves what is happening in the society and why around this topic we cannot find a political consensus, but we can only build some solidarity. Filippo quoted Cutro. There we talked about solidarity, but this does not become politics in terms of choices. But we need to also take into account the candidates for taking political responsibility. This is the topic that should be pondered, taken into account, and we should also try and think of the initiatives that we can do, or also the words we might use, because the political forces that do not consider. So of course, the political issue is also important if we consider the difference between conservatives and progressives. The only government has said in Italy that the only the migration flows should be managed was Draghi government, talking about the entrance of people that were not regularly on the national territory. This is my first question. Second question, considering this episode, we need probably to reason on the point of balance, considering the functioning of the European Union, so between the competences of the member states, competences of the EU. How do provision coordination systems work? In the treaty for the functioning of the EU, there is a compromise. Flows are exclusive competence of states. How entrances are regulated is also object of coordinating actions. If we consider also the topic of borders and international management of borders, but the limitations of the EU are also the limits of the compromise that is reached in the treaty for the functioning of the EU. This is not a secondary topic. I am a trade union member, and of course I also deal with these topics. This cannot be put into doubt by coordination provisions. So this is, I think, something that should be taken into account, because Europe cannot do everything based on the treaty on the functioning of the EU. This must characterize the discussion also. I would like to conclude but with some examples of what is happening, because we are talking about asylum, borders, protection, pushbacks. But I would like to give you some examples of what is happening within the member states, also considering the recognition of universal rights for people that represent a national danger. There are also some measures, welfare measures for families, and those who are abroad cannot use them, cannot benefit from them. For example, a tax deduction or benefits for families. these are not trivial. Or other measures for workers that go that work for a specific period of time, but when their permit of stay, the permit of stay of people expires, they have no other legal protection for their income. In Italy, there is also a law on the possibility of expanding the period of for the permanent of stay permits of stay. Sometimes foreign people cannot have access to a measure if they do not have the possibility of expanding their permit of stay. Recently, an agreement between Italy and Albania has been signed. This is a consequence of the pact. There is a possibility to access a pension scheme after some years of work, and the protection and the international protection. So there is a very big problem, but there are also problems that are enshrined within local provisions for those who own some specific rights, because being legally recognized as local citizen does not mean that there is a possibility of accessing these measures. Why does this happen? This is the point. Not only the tools for the recognition of protection, but also the exercise of some rights that are not part of fundamental human rights, even though we have discussed the human and legal profile, but we are also talking about rights that might be given to the workers, to parents. Workers and parents must be recognized, must see recognized certain rights just because they are citizens or of the EU. So these are the implications, and there are some difficulties in building a sort of sensitivity or in making understand the importance of equality for people that operate within the member states. So there is a double problem, the macro problem, and also a problem concerning how states act. Resources and competences for the access to fundamental rights are also important. Measures to access work or measures to leave the state. Sometimes you cannot leave the state. So why should these rights be denied if there is an 80-day delay or a 1-year period delay in the recognition? So we need to act with legal actions, with legal measures against administrative provisions that are nourished by political choices. Thank you. Thank you, Nicola. On behalf of other organizations, I think we today, after these guidelines of the EU will be issued, I think we should see the direction that we are following. So we should summon a table or a round table, a technical table, in order to see the reactions of the different associations and of the civil society on this topic. Thank you. So in half an hour, we meet again. So at 2:45.
Prova, non lo so, leggo. Prova, non lo so, leggo.
Giusto, iniziamo perché poi è prevista per le 3, sarà con qualche minuto di ritardo il round table coordinato da Virgilio D'Astoli con i politici che abbiamo convocato. Allora, giusto, iniziamo perché poi è prevista per le 3, sarà con qualche minuto di ritardo.
Also, we start even though we have at 3 o'clock other discussions with the politicians that we have invited to the meeting.
Mi è stato mandato il testo di una professoressa che tutti conoscete, nostra amica, Chiara Favigli.
I will not give you an introduction. I will only say just a couple of words to introduce Professor Ambrosini.
Una specie di convegno cugino di quello di oggi. Mi è stato mandato il testo di una professoressa.
I received the text from Chiara Forilli that you all know. She discussed this topic some days ago on the occasion of a conference on freedom and justice, a sort of so similar to today's conference. Chiara noticed something important, an important text. So the first organic proposal of the European Commission in the topic of migration was in 2001, when the Commission dealt with what we call in other sector a clear European spirit, which is an in-depth study of the European society from the demographic point of view on employment topics or expectations or everything concerning the support migrants can offer to society. In 2001, her proposal was focused on a close connection between employment and the entrance to the European countries, which we have discussed today. Flows are entrusted to member states, and over time, of course, flows or migration has been sacrificed in favor of safety, security, etc. So if we want to go back to the origins of the laws and low-level literature, which disqualifies legal provisions of the EU. Please also view the regulation on artificial intelligence. So researchers and the civil society, together with the stakeholders, were involved in this sort of research and governance that is against what we see as stale democracy, or a democracy which has lost all its dynamism also at the national level. If we want to take back that approach, the migration sector is not yet there. So the decision-making processes also influence the populations of the territories involved. So this is why we need to go back to a reconstruction of the situation in progress. We need to know how many people we have as migrants, what are their expectations, where they come from, what they are looking for, if they are looking for integration, etc. So in order to treat in a reasonable and consistent way with human rights, we need to understand what we are now focusing on in terms of regulations. So we are reasoning about the creation of a sort of sociology which proposes a critical framework of the phenomenon to be regulated. Otherwise, our legal inputs and our judicial activism remains blind towards a phenomenon that we should manage. I would like to conclude by telling you something I've found out. A dossier was presented by the Center of Research with works with Caritas. The document concerns the entrepreneurship for migrants in a very constructive approach, because I have found out that there are 500,000 entrepreneurs coming from third countries. They pay the VAT. They are also autonomous independent workers or in general workers and professionals that contribute to the national balance sheet in order to maintain the right level of pension funds for our society. And it seemed to me that this was the winning approach, because it enhances a channel between third countries in Italy, which is also bidirectional. So in one channel, some resources come. These are successful channels. I've heard about a entrepreneur from Peru. She got her degree. She is considered to be innovative, and she manages an activity with European interest. And of course, hearing this news is essential to us in order to spread success stories. And this is especially true to help difficult situations at risk, and to see what a positive impact we might have. So this is quite a precious initiative. This is just a legal channel that must be enhanced and strengthened. We were mentioning the possibility of making permits easier, because 500,000 entrepreneurs are many entrepreneurs, and of course there are hurdles to the entrepreneurship, and this is why they need also our support. So I would like to give the floor to Professor Ambrosini, who will help us through sociology to dissolve our common biases in order to reconstruct phenomena, so that we can understand the current conditions, the status of affairs, and what we should do in the future. Thanks for the invitation, for the presentation. I will try and follow the direction that you have just mentioned. The journey starts with trying to define who migrants are, what we define as migrants. So the definition of the UN is the international migrants follow 3 criteria. They have implemented a form of territorial mobility. They cross the border and they live in another country compared to their country of origin. In terms of boundaries, of borders, what is important is the timing that is linked to what they see as the society that hosts them. Otherwise, they would be tourists. But they remain in the society and they have to do with jobs, services, social status, so they represent the input of certain social dynamics. If we go from the definition to praxis, and some aspects of the legal status, things change. And I will start by my town of origin. I'm not from Milan. I am from Roma. I live in a town in Milan, in the suburbs of Milan, with a Japanese school. I have many Japanese neighbors, and nobody calls them migrants. Then there is the Jewish headquarter, the Jewish neighborhood, or the Arab country. Nobody called them migrants. Then we have 2 families from Tunisia, and nobody called them migrants.
Agli occhi dei miei vicini di casa, bravissime persone di classe media.
Migrants, according to my neighbors, are people who came to live in an apartment of the neighborhood.
E credo di aver imparato qualcosa. Quindi l'immigrazione.
I think I've learned something. So migration, as a British researcher says, migrants are those foreigners that we do not like and that involves some forms of resistance also from the social point of view. As I was saying, for us, migrants are not people from the north of the world, and they are not elite people that come from the south, such as sports people, singers, actors, or business people. All of these are not called migrants by us, and they are not treated as if they were migrants. So they have migrants has a negative nuance. People that are less civilized, less evolved, less modern, less advanced than we are.
Then immigration has a threatening significance. They come here either to be helped or to take away something from us. There is a doctor of African origins working in Lombardy for some years. I think he has become an Italian national by now, and he wrote a book called Imbarazzismi, and he says that the first time he went to hospital, they didn't want him to enter. They wanted to let him in. But then when he really managed to let them understand that he had been hired there as a doctor and he wore the white gown, he said that there was such a magic that everybody was starting to call him a doctor and to have respect of him. And so, there's a social acceptance of recognition, but, this is not always the case. So the migrants have 2 conditions. They have foreigners and they're poor, while the wealth makes you whiter, so to say. And I have some studies talking about diversity and things, and all many sophisticated things, but the point is not the otherness in itself, but otherness combined with poverty. And maybe with poverty that becomes visible, that aggregates in urban spaces, that calls to be to get together because of cult purposes, religious purposes. This is not the otherness of people in the business world. And here we have the philosophers reasoning on the terms that we use. The term non-EU national, you can define it very well from the legal point of view, but in the common sense, I've never heard a Swiss being defined a non-EU national. This term has its own etymological value. The EU nationals are the ones that we consider as being similar to us, people living in the privileged part of the planet, while non-EU nationals are all the others. And the Erasmus project means mobility, but if there are people coming from the south of the world, we don't call it mobility, but we call it migration. Next point. The aim of my presentation is presenting a gap between the commonly meant immigration and the real immigration as it emerges from the statistics that we have. The common ordinary citizens, but also ordinary journalists or ordinary MPs, believe that unemployment is increasing. Some say that there is an exponential growth. The minister said they lost the mathematical sense of the expression exponential growth. The asylum is supposedly the main reason for this. And also the new European Pact, which is about asylum seekers, is defined as a migration pact. So there is also confusion also in this respect between two phenomena which partly overlap, but this is not always true. So the asylum is the main reason for this increase of unemployment, and migrants through the landings come from Africa or the Middle East. The young male Muslims, dangerous, damaging for the finances of the state. Mr. Bronzini was talking about entrepreneurship, and we could also talk about the relationship between immigration and public finance. The statistical data to which we can have access, which are also freely accessible, explain that since 2010, immigration has been stationary in Italy, about 5.5 million people regularly, and 100,000 irregular ones. It is true that 150,000 people a year give up their Italian citizenship, but there are also those that go away, the ones that die. In these 6 million also include small children, newborn babies. So this stationarity can be accepted as such. But the real migrants are people that young adults arriving because they are seeking a job, and then they're followed by family reunifications. And this in the past has been the greatest source of new entries. And in Italy, we had 350,000 in the past, including 40% of Ukrainians. With the arrivals of 2023, we will be 400,000. That is 7% of the total. Our public debate has been channeled around these restricted 7%. The real migrants in Italy are mostly women, and half of them are Europeans. By 3/5, they come culturally from Christian countries, mainly Orthodox, and they have an even number with Muslims. And in addition to entrepreneurship, there is also the fact that 2.4 million have a regular job. And 30 years ago, no one would have said something like that, but it happened. They pay taxes and contributions, and 6 million of them just go shopping. Even if it is the state that pays for them, this is a circular economy. So in the suburbs, thanks to them, the markets are functioning. If they have a means of transportation, they pay the taxes for that. And so some studies say that the migrants also, they are an item of cost. For example, children going in Italian schools, in the end, give a positive profit to the state, accounting for €1 billion. And of all the scholarized pupils, these are a cost for the government, but there are also, on the other side, the teachers that work thanks to them. And also the inhabitants of remote rural places, they have a school because there are also the migrants there. So let's face it, the profit goes towards the central state, but different costs connected to migration, for example, social housing, are costs that fall on the local finances. So there is a difference between those who receive profits and the ones that bear the costs for it, costs connected to migration, of course. We also have to consider the distance between the perception of reality and the reality itself. There's a lot of overestimation. In receiving countries, they see around more migrants than there actually are. And in between, there are us. We Italians are at the top of the chart. And the Italians see in their country about the triple of migrants that are really there. 26% of the population see 18 million migrants in this country, while there are less than 6 million. Why that? Well, sociologists would like to look for an explanation. I have an idea for that. We probably project our frustrations, our fears for a country that is not growing, our concerns for the future, and we want to blame it all on a migration. This is just like a scapegoat for the Italians. But borders are selective indeed, as Professor Arrigo said this morning. Selectivity that is expressed around the three variables: passports. Some countries, including Italy, have passports that allow a visa-free access to most worldwide countries. On the other side, we have nationals of countries that can hardly have access to 30 more countries without a visa. Then we have the portfolios, and legal experts know this very well. All countries envisage privileged entry visas, golden visas for wealthy people. In Italy, in July 2023, the golden visa has been abolished for Belarus citizens, and we're almost at war with that country. But until July 2023, wealthy people from Belarus could have access to Italy with their families and their assets without any limitations. Some countries go even further, also within the EU. Malta and Cyprus grant citizenship to wealthy people who settles down in their country and deposits their money there without any expiry for the length of stay. And then we have the professions. In Europe, we have the blue card, which is little known in Italy, because we attract a type of migration which is also skilled, because we have women working in Italian families who sometimes are educated, but we use them for low-skilled jobs in Italy, with an exception, the healthcare system. I was talking about the white gowns before, and we have healthcare professionals of a foreign origin, and the International Labour Organization estimates that there are 100 million of healthcare professionals working outside of their country of origin, which means that the north of the world uses people from the south of the world for the care of fragility or frailty refugees. This is the most controversial topic in this period. It hasn't always been so. There was a time when refugees were more accepted than people seeking a job. And so now we have a different direction. Here, the essential data is that 3/4 of the world's refugees are received in low to middle revenue countries. The EU in 2021 received, according to Eurostat, less than 10%. In 2022, there's been the invasion of Ukraine, and 4 or 5 million of entries. So the numbers went up to 14%. What remains is that one day somebody will cynically study with a great detachment offered by time that we will convince the Europeans that we are under invasion. So the most recurring word today is repatriation. I haven't seen the latest version, but in the September version, the return term was present more than 20 times, together with the admission of a failure in this area of migratory policies. So the main aim is increasing the returns and also trying to curb the arrivals. And despite the representations, most of the refugees are women, and a large part of them are minors. The most involved countries are Turkey, which is the first one for the reception of Syrians, Iraqis, and Afghans, but Iran probably this year will just surpass it, and among the 10 first European countries in terms of receptions, there is Germany. But if we look at the ratio with inhabitants, it is always the external countries that bear the greatest burden. With Lebanon, for example, 1 refugee every 7 inhabitants. In the EU, we have Sweden with 1 refugee every 40 inhabitants. Italy receives 1 out of 175, including the Ukrainians. We are below the average of the European Union. And this is why the Italian government is not talking about the redistribution so much. They say that we should stop the earliest migrations because probably somebody has shown them the statistics. Look at the recent arrivals. Asylum applications in Europe in 2022, 1 million. Italy, 77,000, 8% of the total. The rhetoric of Italy as a refugee camp of Europe is once again a political invention, which is very successful. And even one of my illustrious colleagues, Marisa Ferreira, just swallowed it. And today he said that Mediterranean countries are under an unjust pressure compared to other countries. He probably doesn't have the right data at hand. He probably watched TV. Now I'm going to write this to him. As for the relationship with poverty, there's a lot of rhetoric to be dusted off. There's an increase of inequalities, and mostly migrants come from a poorer country to go towards a more developed country where they can hope for a better life. But that's true in relative terms, because in absolute terms, international migration has grown. Today, we are about 300 million international migrants throughout the world, but the percentage of worldwide population is stable, 3.5%. This has grown by 0.2% over the past 20 years. And this means that 96% of humankind doesn't leave their country. Also, they are not happy to be there. And I can understand them because, I never go too far away from my home town, Vercelli. I just went to Rome. And I'm still suffering from that, not from the wedding, but by the shock, because I moved from a little town to a large city like Rome. So if you want to migrate, you need to have a very sound body. You have to adapt yourself to live in a country whose language you don't know the rules, you don't know anyone. And you have to, to make a living, to try to understand how you can access the labor market, etc. And so there are relatively few people that migrate internationally, and most of them do not come from the poorest countries on the planet. The first countries in the world in terms of migration are India, Mexico, Russia, and China. Well, these are large countries, of course, but if we consider demographical dimensions, we can find Africa here. More than 30% of African mobility, sub-Saharan mobility, happens within the region. In Italy, we have the same classification. Romania ranks first, Albania second, intermediate countries, not very poor countries, not countries where people are starving in the streets. There are very important studies that have found that people migrate, especially in the range included between 1,000 and 8,000 euro in revenue per capita. In order to migrate, you need resources. And in addition to economic resources, you also need cultural and intellectual resources. People that have an education tend to migrate more compared to the others. And also the people that have a connection in another country tend to migrate more than others, of course. So worldwide, migration is an extreme strategy of defense from a lifestyle that you don't like in a middle class environment. But landings are the most visible and dramatic form of entry, but it's also the most monitored one. If you go to the Home Affairs website, day after day, you can see how many people landing and where they come from. But irregular entries come especially through the channels of physical entries with a visa if necessary, but the European Union doesn't request a visa from 50 countries in the world. For example, all coming from the Balkan areas, including Ukraine, Albania, Moldova, for a stay shorter than 3 months. I'm getting to the conclusions. We should say that we need a worldwide or European governance of migrations in order to favor safer and more regulated migrations. But Italy hasn't even signed the documents of the UN on this subject matter. We should also discriminate different statuses of migrants. If we ask ordinary people if they're in favor or against migration, what do you think most of them would respond? maybe I would find it hard to say yes to migration, because what do you mean by migration? But if we ask more precise questions, maybe we can get better answers. As I said, doctors or nurses, do you want them or not? And carers, do you want them or not? So we have a cartoon by LK saying, we could wish it to xenophobic people in Italy, and somebody answers, a carer that wants to take a revenge on them. Do you want students or not, for example, to increase the rankings of our universities? Do you want family reunifications or not, or you want them to remain lonely so that they get crazy, maybe? If we ask more precise questions, maybe we will have better answers. Also, for what concerns labor migration, which has become trendy once again nowadays, I think it is important to go beyond a Gastarbeiter vision of Germany and Switzerland of the 1960s. If you see large flows, you can say, we want to have laborers entering our country, but we should introduce a sponsorship figures, because the migrants arriving and having somebody receiving, welcoming them, and also helping them, they can find their own way in a better way through many internationally conducted research. We know that this is true.
Lo sponsorship servirebbe.
Sponsorship would be better in order to integrate these people. In terms of humanitarian topics and refugees, there are solutions that most of you know. There are settlements operated by the states after the pandemic, 100,000 per year. But considering a number of people that the UNHCR has already assessed as entitled to settlement, then this is possible. So there is the legal tool, but there is a lack of willingness to implement it. Then private sponsorships. More than 300,000 people came to the country through sponsorship. Associations, religious communities, citizen groups, companies, sometimes, so that the refugee family comes and will be maintained 1 year long, or 40,000 settlers. So there are students at risk, scholars at risk, and projects that are aimed at helping some specific categories, for example, sports champions. And this is one of the possible channels. Or humanitarian safety nets, safety lines that also include religious communities that allow 5,000 people to come from Lebanon, from Ethiopia, from Afghanistan, and other countries, with projects with which we also collaborate together with some international institutions, France, Belgium, and Germany. Also, in a limited measure, contributed to it. So there are some legal tools that should be supported by the right political willingness to do so. So I think there is much to work on in order to build a world where human mobility is more widely accepted, especially for humanitarian reasons. Thank you.
Grazie mille, professore, mi scuso per averla interrotta.
Thank you, Professor, and sorry for interrupting you. I think that if citizens reflected on 1/10 of what you have just said, our choices and their choices would have been different and would be different, because many myths were debunked. And probably you can send us your slides so that we can start a debate and exchange of views. I think we can start a different narration. One of the limitations, as we were saying this morning, is that this pathway of regular migration is not taken into account. So the 2 billions that are collected are not enough in order to find an alternative of such measure. Now we have Pier Virgilio Dastroli as the moderator for the political movements. Thank you. Thanks, everybody. I was involved in another conference this morning concerning law, information, and freedom of expression. As you well know, in Italy, but also beyond, there is such an issue. I am the grandchild, the grandson of migrants from the region of Calabria, in the south of Italy. People from Calabria were considered to be migrants at that time, and we could not rent apartments. We were just people from the south of Italy. Just to give you a short introduction of myself, I am the president of the European Movement Italy. For many years, we have been dealing with these topics. Over the last few years and months, our commitment has increased. We have talked about the Krotos strategy, the Krotos problem, and we also supported the initiatives of European citizens and about migration policies. At the eve of the European Parliament, last year in June, we expressed ourselves about an agreement which was an historical agreement. We made history. With that vote, we didn't make history, we made anti-history. All groups wrote to the European Parliament by expressing some of our dilemmas before the vote or some criticism. We know that this pact overcame the Dublin agreement in terms of control procedures at the borders. As you well know, solidarity is not, as Juncker said once, a voluntary fact, but something binding, a binding fact. Money is paid to countries in order to strengthen frontiers, to strengthen borders. So voluntary relocation, article number 80, is denied. There are some reception centers that we call detention centers. Through bilateral agreements on a legal basis, even though we think they are illegal, this becomes possible. Another thing that we said is that there is not much transparency There are many things to be carried out, commitments to Africa, the Mattei Plan. Something very serious is happening in Africa. The European Commission has just increased conflicts in countries such as Rwanda and Congo. In terms of raw materials, there are no European rules, no controls of weapons sent to third countries. Weapons make wars, not peace, as we mentioned this morning. So we gave up on having a role in Africa. There is no commitment to support NGOs or humanitarian lifelines. In Canada and Germany, some organizations are there, in Italy too, but nobody knows it in terms of consequences of migratory policies. There are some candidates from the Balkans and Eastern Europe. We thought that the choice of approving this change, this amendment, the 10 points of the Migratory Pact could be taken into account, but this didn't happen. There was a limited majority. Let's see what the Council will be able to do. We have proposed over the next legislature, we will need to review the pact, and at midterm office, we will reopen the discussion through a negotiation between institutions, and in 2026, a conference will be organized, such as the Conference on the Future of Europe, where we can discuss with the NGOs and the social parties, as well as the social partners and the observers of the candidate countries. We know that these issues also put in doubt the respect of fundamental rights. This pact should be implemented. This idea has been partially shared. We need to understand which majorities we were able to build at the European Parliament. This has to do with the balance sheet and other aspects. So our proposal is to review the balance sheet in midterm review of the balance sheet, and an internal review in terms of the agreements on the review of the Dublin regulation. We will work on this topic together with other organizations. We will relaunch the idea of gathering around the table in order to talk about migratory policies and asylum. I would like to stop here. We have from remote other speakers. Please, you have the floor.
Grazie per questo convegno. Non l'ho potuto ascoltare tutto, ma la parte che ho ascoltato è stata davvero interessante e ci consente
Can you hear us? Yes, I can hear you. Can you hear me? Sorry, but I'm having some issues with technology. So I was following you on YouTube. Thank you for this conference. What I've listened to was very interesting, and it allows us to focus on different tools that should be used in order to try and win a cultural, social, and of course legal and legislative battle. This battle involves the idea of Europe that we have, as well as the civil society and the life as citizens. I would like to start by mentioning what you have already mentioned. So the fact of trying to reopen the discussion at the European level in order to regulate migration, because we had we failed. There was a dramatic failure of the civil society. It seems to be inhuman and irrespective of the rights of people after the Second World War. So our continent is brought to a new phase in history concerning not only new legislation on migration, but also human rights. We should also stress that the disruption of the center-right government, which votes for the new pact, and Piantedosi, which says it's too little, so we should do more. It's just a political shield, but the mechanism is based on the idea of closed centers, such as the ones we have seen in the Greek islands. This represents a model that is very similar to the one that the Italian government is looking for, because they want to build these centers in Albania, which are very expensive, but also but they are also centers in violation of human rights and conditions. We consider to be unacceptable the administrative detention centers. So this is why we are, of course, absolutely against these centers, which show our failure and the failure of the European civilization. A new pact around the administrative decisions and the division between those who come from safe countries and those who do not come from safe countries, the abolition of the right of asylum. Everything is dramatic in terms of flexibility of migrant receptions. The European countries have some compulsory provisions to abide by, but they might decide to give also 20,000 euro for a migrant to the first arrival country. So this means saying a center-right government, as the one in Italy, we will not take your migrants, but we will give you the funds so that you can keep your migrants along the coasts of Albania, so that they can sign pacts that should not be lawful. 650 million euro, 900 million euro is what we spend in order to welcome 39,000 people. This is what our Prime Minister Meloni says. She treated this element so as to make everything, so as to mitigate the burden on the Italian budget. Of course, we need to face the European elections by trying and bringing to Europe a consensus and parliamentary representativity so as to avoid a majority that goes towards the right-wing direction. Otherwise, the migration pact will get worse, and we need, of course, to avoid this majority to be built. If I'm talking too long, please tell me. So we need to fight a political battle in our territory, a cultural battle. This is what we told before when talking about migration. So considering the last also suggestions from sociology. So I agree, and I think that your approach is entirely based on human rights. I think this approach was not enough to face up a wave of new racism in Italy, based also on the discussions that we are now conducting about schools, first cycle schools. So there are many occasions to treat students in discriminatory terms. And this also goes beyond considering the whole debate of the last few days. So these topics are not treated as they should, but they are instrumentalized so that the wave of racism and discrimination grows. So I think it is necessary to choose the right battlefield from economy, from demography. So these are important fields for those who, like us, try and conquer the consensus of people and to change laws and provisions. We need to describe the situation, the migration situation as it is in countries. We need to build projects and to support projects in local communities so as to be knowledgeable with discriminations and biases, and we should also try and take this special projects on migration. This is important. We should say migrants that grow and collect olives, that grow olive trees and collect olives, so that we can also tell how, when there is knowledge, when there is mutual knowledge, the racism wall is broken down and the color of skin is not important anymore, in spite of the racist thoughts and ideas that are now in our country. So demography, politics, special projects, etc. We will not be able to face this situation without rethinking our economy as an economy for taking care of people. We talked about welfare, but we also need to discuss about redistribution. We need to follow the logic of project design, project building. We need to create occasions to do that, because in this case, this way, we are able to establish a virtuous dialogue. Otherwise, we remain inside a frame, as a famous writer was saying, a frame that keeps talking about right-wing ideas. Otherwise, we need to implement new positive frameworks that are full of hope for people in terms of equality and rights. Thank you. We will keep in touch to work together.
We have Pier Francesco Maiorino connected with us. He's responsible of the Democratic Party, and he's gonna talk, and he's just responsible for migration policies. Is he connected? I saw him connected before, but I can't see him now. So maybe we could switch the order. We have a video that Professor MP Smerillo sent us because he couldn't attend, so we can show the video in the meantime while we wait for Francesco to get connected. Smerillo is a MEP. Hello, good morning. Thank you for asking me to address this audience. Very recently, we voted at the European Parliament on the Migration Pact. Well, what happened is quite a negative thing, and I really don't like this new organization. And doing this on the eve of an electoral campaign that is going to be very harsh, especially on some topics, namely the migratory flows and the nationalisms and return racisms. Certainly it wasn't helpful for this debate. And it's too bad that many progressist forces really joined this, always by reason of reducing the damage. But since the damage is represented by human beings migrating for a number of reasons, I think that this approach is really wrong. Together with others, we have followed the indications, suggestions, and also the reports with over 50 civil society organizations that signed a common statement opposing this new pact on migration, saying that in its current form, the pact is giving the go-ahead to detention, pushbacks, racial appropriations, just denying the fundamentally human rights of searching for security. And we are convinced of the same. And unfortunately, it wasn't the majority of us to be of the same idea. And we voted for all the regulations that were against, 9 regulations and 1 directive. More specifically, in relation to the directive on the conditions of reception, the member states will have 2 years' time to introduce modifications, amendments to their national laws. And more specifically, we have one screening regulation, which is very dangerous indeed. It is called the fast track regulation, which introduces the screening of third country nationals arriving to the external borders of the European Union with the so-called hotspots or external detention centers outside of our borders, which are less easy to be traced, to be monitored, so we can't make really efficient verifications for what concerns the respect of human rights. And with the procedure of holding of 7 days in order to collect information before leaving them to the responsibility of the competent authorities. Within 7 days, they have to rewrite the history of that people. And if that seems to be consistent to the people that will collect this information, there will be a new procedure of repatriation for these people. So they will be repatriated to countries that they left many months earlier. The regulation on the third country national for the screening and for the criminal records, this sets a common procedure for the treatment of applications of international protection by member states, including also the extended use of special procedures at the borders, the concept of safe third country, but certainly this safe third country raises doubts on the protection of human rights, because it is difficult to define a safe country as safe if that is the country that these people fled. We have this Eurodac that is turned into a broad information system containing personal data of the asylum seekers, raising concerns about the privacy and access of law enforcement agencies to the data. And there is also the issue of biometric recognition for children under 6. So this is really a critical situation. And then we have the RAM regulation that sets criteria for the competent member states in the assessment of the application and the mechanism of solidarity between member states, with financial contributions to support projects in the sector of migration and asylum. And thus as well the crisis regulation, repatriation regulation, resettlement regulation, and also from the political point of view, I think that we have approved things that are really devastating for Europe. It makes it a really closed fortress with very closed borders, and with the process of selection of people allowed to entry, and it doesn't ironically solve for right-wing parties, especially for the Italian government, the issue of the country of first landing. So this remains just the same. And for those who are not in the condition of a voluntary redistribution, they will have to pay a duty, but there won't be a shared solidal mechanism. So the problems of the nationalists will not be solved with this. And so the image of Europe in the world is strongly impacted by these regulations, which are pejorative of the current situation, and which really spoil the history of Europe as being a land of solidarity and reception, with a very worrying racial trend. We had also invited MP Riccardo Maggi, but he couldn't get connected because he is a member of the Renew Europe party, the European Liberal Party, but he can be with us today. MP Maiorino hasn't connected yet. So I would like to invite to the floor Ms. Okonska. Can you please come to the podium? Good morning. Are you going to speak English? Are you? So for those of you who do not understand English, you can use our simultaneous translation service. And I take this opportunity to thank our interpreters.
For inviting me to this conference. I have been dealing with migration issues for many years, both from practical and political perspective. So I speak in English. Hello to everybody, ladies and gentlemen. Thank you for inviting me to this conference. I have been dealing with migration issues for many years, both from practical and political perspective. So I would like to present to you some of my comments on the new pact on migration and asylum that was adopted today by European Parliament, only thanks to the abstentions which were used by MEPs who did not agree with the text but wanted that the pact to be adopted. I believe that the provisions of the pact do not protect human life and fundamental rights. And we have to take into account the safety of people and who seek international protection or a better life. Monitoring, guidance, and legal challenges will not be pivotal. The implementation should focus on long-standing compliance problems rather than border procedures. It is the time to tackle backlogs, appealing reception conditions, asylum lottery, neglect of procedural rights, etc. The principal aims of a new pact are to introduce a new border screening procedures, to improve relocation procedures for vulnerable groups and people rescued at sea. This was called as solidarity aim. To support other countries hosting refugees and fight migrant smuggling, and to ensure a common and fast reaction on migration crises. Theoretically, they are the very good aims, but I believe that the weakest point of the pact is the assumed solidarity of the member states and its flexibility. Unfortunately, member states are rejecting this solidarity, including my country. Poland explains it that it accepted 2 million of refugees from Ukraine, but that was 2 years ago. And today, these refugees are mainly in Germany, in Belgium, or in Netherlands, or other rich countries. In theory, the assumptions of the idea of solidarity are relocation on recently arrived people, reception of newcomers or return operations, and assistance in responding to specific migratory trends affecting member states through cooperation with non-EU countries. The last proposal is quite unclear to me in the light of activities outside the pact leading to the externalization of migration proposed by the Commission. This proposition opened the way to the externalization of the granting of international protection and asylum. As you know, lately the European Union signed agreements with Tunisia and Egypt in which it committed to large financial support in exchange for its help in the fight against illegal migration to Europe. However, the conclusion of these agreements aroused considerable controversy among European politicians. There are many accusations against Tunisia and Egypt as countries where there is a dictatorship and human rights are violated. As a result of these agreements, the situation in Southern Europe has not improved at all. An example is the Italian island of Lampedusa, where the number of illegal migrants has exceeded the number of inhabitants in recent days. So the question is whether the European Union should stick to an agreement that is expensive, controversial, and doesn't work. This migration crisis in Southern Europe continues and is even intensifying despite the agreement between the European Union and Tunisia and Egypt aimed at stopping the influx of illegal migrants. You can see how weak the pact is, as the Commission has to rely on the regime of Turkey, Egypt, Tunisia, and Libya. It seems that the much earlier experience with Turkey, which was supposed to stop the influx of Syrian refugees, did not teach the European Union anything. I was in Turkish camps in 2017 and knew the consequences of this agreement. Refugees living in overcrowded centers or resting in makeshift tents. I think the reason for the recent deals is primarily to show before the European elections that the governments of EU want to show how much they care about preventing the crisis. Europe is becoming a fortress intended to protect us against the influx of migrants, although this protection is only apparent. From my experience, I know that people looking for security or better living conditions will conquer any fortress. I believe in legal routes, migration routes, in solidarity in sharing the wealth of European countries, and in respecting human rights. I believe that the pact should not only be based on the values that are fundamental for the existence of the EU, but much more important that those rights should be respected. Finally, I would like to show you some photos, but I don't know if I am connected. Because Joanna Sikora showed us, spoke about the Polish-Belarusian border, and I have some photos, but they are on the Facebook. You can email this to me? Yes, I will email these photos, and you can see what really happened on this borders, which is the shame for Poland. Yes, yes. Thank you very much.
We welcome your independent approach and the activities of your humanitarian association in Poland. That for us is very important to show that there is a network of organizations that work to not only to respect formally, but to work in view of the humanitarian rights. Your association, from this point of view, is very important for us.
Thank you.
I don't know. Guarda, Pierfrancesco è collegato. Ciao Pierfrancesco.
Buongiorno, buongiorno a tutti, eccomi. Mi sentite?
Sì, sentiamo e ti vediamo.
Grazie, quindi dico alcune cose, mi scuso molto della modalità e della forma, delle condizioni del mio intervento, ma insomma ci tenevo da...
So, sorry for not being able to be there, but I would like to thank you for this opportunity and the contribution you are giving to us in terms of what Professor Ambrosini has just said. I think that he focused on the right issue, so the national and the European policy that is a very national one. This is a rhetoric that was born on a negative basis, so it was not easy at all. The idea is that of governing and managing the phenomenon. I think that numbers are not enough. What we need is radically different policies at the national and European level. We need to overcome the Bossi-Fini law, and we deputies for the Democratic Party are now submitting a proposal following this direction, and also the temporarity and the sponsorship will also be needed, but we also need some pathways, some directions towards integration and social inclusion in our cities and communities. This has an impact on the national social initiatives. I think they are not a failure. So I think that we did not fail. And I think that Meloni, the center-right government, is not a failure. But I think the goal is that I think that there is a permanent emergency, that is migration. And all policies following this direction are too much conditioned by emergency and not by managing the issue in a rational way. So I think the pact is a missed occasion. Our deputies did not vote it. So they refused, they voted against some parts of it. Today, some newspapers wrote something about it, but they confirm the logics of Dublin, of the Dublin regulation, and the philosophy is similar to the national negotiation. So migrants are not seen as people with the true life and true real conditions, but they are seen as a damage to be removed or to be reduced by reducing the damage, by reducing migration. I love the philosophy of damage reduction, but not in this topic. We need to reach a more consistent system of national policies that we need to implement, and also in terms of administrative and local measures that we need to implement we need more radicalism, which might become the lever for new inclusion criteria. I'll give you an example. If in a town, in a neighborhood in Milan or in Rome, if there's no access to popular housing and the family of origin is foreign, and there are many minors, much more than in an Italian family, then there is a sense of marginalization, which becomes a clear manifesto so in order to affirm the idea of defending oneself against what is happening.
Ovviamente tutto ciò vuol dire scommettere su canali d'accesso regolari e di accesso legali e sicuri.
We need to have one more house. So if there are not the right policies, then the migration issue will be conditioned by negative passions, by hate, and the response will always be the emergency response and not a rational one. So
un ufficio stranieri da fila e non si debba poter andare in radicalmente divisa, e credo, chiudo,
I believe that at the Italian level we should remove from competences, from capacities from the Ministry of the Interior in favor of migration policies. So this means also giving a new structure to our public offices by getting out of the fear, the logics of fear. Over the last few years, the debate on migration has been conditioned and influenced because there was a cynical political idea on the one hand, and on the other hand there was a certain weakness. So the logics of fear cannot determine the choices on migration, because we are not going to the right direction, we are going nowhere, and the only voice that will remain will be that of emergency, with the image of ships and shipwrecks. But we need to avoid these people come to our country on boats, and this also increases the exploitation of people, and we need just to use new measures and tools. So thank you for your initiative. Thank you, Pierfrancesco. We have always shared this idea based on which migratory policies must not be the competence of the Ministry of the Interior, but they should be the competence of those dealing with reception, with social assistance, social support. So thank you, and we are now at the end of our roundtable with politicians. I now give the floor to the next session. Monica, please, you have the floor.
It's great honor for me to be with this panel together with Orhan Karabachak, who is here. He is a former judge from Turkey, and he had to flee from his own country. That was 2 years ago, right, Orhan? 2 years ago.
So we move on, and we will speak English now.
So to be with this panel together with Orhan Karabachak, who is here. He is a former judge from Turkey, and he had to flee
from his own country. That was 2 years ago, right, Orhan? 2 years ago. He managed to flee through the sea. So he's going to present us his personal story, and I think this is so important. After all this theoretical part, just to focus on the real lives of people who suffered and who can tell us about the migration problem from this other perspective. And we have also Kasia Smutniak, who is an actress and film director from Poland, living in Italy. And she made incredible movie La Mora, which is about the problem. Well, it's not like the right word to describe it, but the crisis on the Belarus border. And she was one of the very few people actually who had access to this closed zone on the border with between Poland and Belarus. So we shall begin with a short clip from Kasia's movie. Unfortunately, we are not able to present the whole movie because of the time limitations, but at least something.
Ze spodni, bata. Znaczy się, że chodzą. Zaczynamy. Tak.
Ok, andiamo, corri. Czy nie składamy?
Straż stała z żołniem może?
Prepara la chiave della macchina, ok? Drone? Dai. Sì, ti veloce. C'è un drone che ci sta inseguendo, vai. Ok.
C'è troppa polizia.
Could you please tell us your story?
So first, maybe let's begin with Orhan Karabachak. Obviously, what we've seen, it is about totally different environment. It's a Polish prime forest, and but can you find yourself in it? And could you please tell us your story? Why did you decide to flee, and how did it look like?
We can manage. Okay, easier than expected. Please.
First of all, I want to thank
Italian international
for giving us this
gesture for
beautiful place.
anything, basically, from help to we can manage.
Who I am.
Okay, easier than expected. Please.
My personal story. First of all, I want to thank Rome Tree University for giving us this beautiful place and floor. And this is a part of who I am. And before coming to my personal story, I like to describe how Turkey was dragged into chaos and major events, important events took place in certain direction. first major event was the Gezi Park events, 2013. And actually everything has begun with this protest demonstration. The cutting trees in the center of the Istanbul grew into large popular opposition movement against the Erdogan regime. Right after the protest, the Erdogan declared demonstrators as traitors, the demonstration itself as coup against himself and his government. And then he and the government reacted harshly, and many people were arrested. As you may know the name Osman Kavala, he is one of them. He is still in jail, allegedly or involving this demonstration. The second important event was the largest corruption investigation in Turkish history. The corruption was carried out against the then ministers, and their family members were prosecuted based on some significant corruption allegations. However, Erdogan and his government reacted harshly again and described the corruption investigation as a coup against himself, and then those who conducted this investigation, police officers, judges and prosecutors, were removed from their profession and then put in jail, and they are still in jail. And in the same period, Erdogan put heavy pressure on media and closed down many NGOs and media outlets unlawfully, of course. And then this was the, I believe, the most important event in the Turkish, recent Turkish history. And it marks the rapid and dramatic break with democracy, human rights, judicial independence, and the rule of law in Turkey. And in the evening, 15 July, a coup attempted. Right after the first movements on the streets, like around 3 a.m. at night, an arrest warrant was issued for 2,840 judges and prosecutors, while even the perpetrators of the coup attempt were unknown. And in the list, who was going to be arrested according to that list, in the list there were judges who passed away long before and retired long before. And this alone raises serious questions about the true perpetrators of the coup attempt. And 5 days later, government declared state of emergency and suspended numerous human rights embedded in the constitution. And between 2016 until 2018, 2 years period, state of emergency period, 4,000, you see the figure here, yeah. As you see, approximately 4,500 judges and prosecutors were dismissed from their profession and were put in jail, arrested, many of them. And of course, simultaneously, many military officers, police officers, teachers, academicians, just name it, almost from all professions, people were arrested. Some of them still are in jail. And you can imagine the climate in Turkey. The climate was full of fear, and fear has pervaded society. In this fear, Erdogan benefits from that fear. And he has the tool to destroy judicial independence completely. Now, let's begin my story. The night of the coup, I was in my village having my vacation, and then I received a message from High Council for Judges and Prosecutors. It was saying that your vacation is cancelled, return to your court. Then I left my family and set off the road towards my office, my court. On the way, the bus was stopped by the police, and then they arrested me there. I asked the police, I'm a judge, you cannot arrest me like this, I have constitutional protection. And they said, we don't have any idea. And then I reached the prosecutor and asked prosecutor what is going on. And he said, I have no idea, but the arrest warrant is coming from capital, Ankara. And then he sent me to my city, and I appeared before a judge, and judge arrested me and sent me to prison. Upon my appeal, 4 days later, I was released from the prison, and I was on probation for 7 months. Every week I went to the police station and signed the paper documents, and at the same time a travel ban issued on me. And then, but at the end I was free. Until the day we were celebrating my daughter's birthday, police appeared before the door and arrested me again. And simultaneously they froze my house, my car, my bank accounts, everything were frozen. I couldn't sell any of them. You need some kind of financial support, you know, to continue your life and your life of your family. And then this time I was sent to a prison far away from my home, and it was for 18 months. I was held in a prison cell. It was originally built for 9 inmates, but we were 24 inmates. I slept on the ground 6 months, waited for a bed, dirty bed, and then 18 months later, I was released. I was set free, and then I start to look for a job. You know, life is going on, but nobody wanted to hire me because of their true concerns. They told me that if we hire you, then the government sent us inspectors, and our financial situation got into trouble. Then that's why, sorry. And I worked as a truck driver, delivery guy with my brother. And meanwhile, my wife, she was a teacher at public school. My wife and I have 3 kids. My kids were under psychological pressure in their schools. At the end, we decided, okay, life is over for us in Turkey. We must leave this country. I also started to believe that I'm a kind of emotional. It wasn't easy. I don't know. Yeah. And then every time I speak about this issue, yeah, I remember my memories, so it a little bit hurts. Sorry. I also start to believe that I'm a kind of emotional man, I don't know. And then I didn't trust smugglers. I found my own way. I got online education, how to operate a boat on the sea. And then several months later, I got the license. It was necessary for me to operate a boat for training in the domestic waters. When the Coast Guard comes and asks you, yeah, I have the driver license for the boat. And then in our first attempt, we purchased a 5 meters boat with my former colleagues. And then in our first attempt, it was total failure. We couldn't make it. And we lost our confidence, of course. In the preparation of our second attempt, the boat sank and then upside down. However, luckily, actually, it was close to the coast and we barely saved our life and back to the coast. And that time, okay, Orhan, it's time to give up this idea. However, then we looked at the situation in Turkey. There was no life. So, like, I feel obligated to flee. And then, okay, let's do it one more time. In our third attempt, we made it and reached Greek island. I was arrested on the island for crossing illegally the border, and 4 days I was held in detention center. It was so terrible, the conditions were so terrible. There were immigrants, the refugees from Afghanistan. They were there for 10 months, more than 10 months. You know, you cannot live there 10 months. And then I never forget the support from the Medal. At the time, the president was the Philip Marquez, and he helped me a lot. And then I got Athens, the capital. Everybody knows where to go and how to get fake passport. First, I got the Portuguese ID. I was Miguel dos Santos, but it was so fake that at the airport the lady just, oh, it's fake, called the police, and then I was briefly arrested at the airport. And then I must have tried again, and then in my second attempt I became Serbian citizen. I was Andrew made it, and I reached Amsterdam, and now I'm a refugee status holder, we call, and in Netherlands I have 3 kids, wife. I am a student now also at Tilburg University. I will be graduating again law school after 25 years later in this summer, I hope. And by the way, I forgot some pictures, but I feel myself still lucky. This is the true picture, the true moment, the exact moment while we were crossing the sea. This couple, prosecutors, they died while crossing the sea on another occasion. This couple, both judges, lost their kids, and they buried their kids, as you see, on the Greek island. You know, lots of stories like this, you know. And this guy is our president, the president of Turkish Judges Association, and Václav Havel Human Rights Prize winner. He is still in jail. He's 8 years now, from 2016 until now. And this is the just little bit other part of the story. This is this was actually this president of the second largest opposition party, Selahattin Demirtas. He is still in jail, and as you see, the many mayors elected removed from their positions unlawfully. However, in the last local election, and they got back their seats, of course, with different faces. And the last election also shows us that the pre-election period was not new normal for Turkey. We should not accept Turkey in that situation. Turkey must stay in the EU. We have Western values, people with Western values. That's why we shouldn't accept this current situation in Turkey as new normal. And this is the guy, the president of Progressive Lawyer Association. He is also in jail now, 7 years past. And his colleague died on hunger strike, demanding fair trial in jail. And some bullet points. Yeah, you heard a lot from theoretical perspective. Just this is my view on the subject. First, 2016 EU-Turkey deal has been a shameful act for the sake of humanity, and shameful deal has become blueprint for EU, unfortunately. And I believe that the quality of democracy under the rule of law in a country can be measured. The protection given to refugees, prisoners, and ill people, the most vulnerable ones, not the most stronger ones. You cannot measure how the state of rule of law in a country with looking at the so-called normal people in normal situations. And asylum seekers, refugees encounter many difficulties, pushbacks, inadequate receptions, lack of legal counsel. In some countries, like Belgium, which seems among the best according to rule of law indexes, even court decisions to accommodate refugees are not respected and not implemented by the government. As we also see some other countries push back practices and complicity of some Frontex officials have been revealed. However, it is interesting that EU Commission's annual rule of law reports persistently keep ignoring asylum and refugee issues. Rule of law is not a la carte, cherry-pick concept. You cannot say there is an established rule of law system in a country which turns blind eye to what's happening in this certain area. And this is the most important part for me. Yeah, it's important. Solidarity is what have been experienced and what have or some people like in my situation most needed this solidarity, the hope, but this hope is not the hope we are talking in their daily conversation. The hope makes us stronger, give us strength. This is the hope I'm talking about. Not the I hope I want to go there. Not it. This is the hope which gives us strength, and we got this hope from medal first, and then I will just introduce this actual privilege for me, and it's a chance for me to thank you before such distinguished people. And as you see, right after the coup attempt in Turkey, we were removed and put in jail, and Gualtiero gave the first and the fastest reaction to our dismissals, and led the establishment of fund, and it still gives financial support to the families of incarcerated judges and prosecutors. And Philip Marquez, he is not here. Just skip this part, of course not. Philip led a kind of campaign, I believe never been seen in the history, and he was labeled as enemy by the Turkish government, but he never backed down. And Maria Rosario, our president here, she signed lots of important documents, at least important for us. I am sure he also contributed to the cause of other countries like Poland. And this is the last part. And I would like to extend my special thanks to the presidents and honorable members of Italian Judges Association, which is they called Umbrella Association, and Magistratura Democratica. Presidents here, thank you for your valuable contribution. I cannot enough thank, sorry. And Carlo Sabatini, he is not here. one of the Italian delegates, and Giovanni Canzio and Giovanni Salvi. He is here, and I just told him why your name is here. Since our removal and arrest, they organized many events before the courts in Italy. Thanks so much for your patience.
Thank you, Orhan. It's always very touching. I can only add, but with Medell, we try to convince European Commission that they should include migration policy in the rule of law report. Unfortunately, it seems that it's better for them not to perceive this in this context, so far at least. So shall we watch this second clip from the movie?
Jak te osoby w tej czerwonej strefie mieszkają? Jak te osoby w tej czerwonej strefie mieszkają?
Tutaj jak gdyby nie ma problemu, jeżeli oczywiście rodzina, lekarz, tutaj jest też wykaz osób, które bez problemu wjeżdżają i jak gdyby nie jest to odczuwalne w taki jakiś sposób bardzo uciążliwy.
Pani też to tak, to pani? Wie pani co chodzi?
No nie widziałam.
Tylko sklep mechaniczny.
No chyba tutaj.
Sklep kościół.
O, sklep kościół i
Centrum.
tutaj centrum.
Dzieci w szkołach.
O, tu pani może porozmawiać z wami.
Dzień dobry.
Nie, pani nie chce. Bo pani też nie chce.
Ja się spytam.
Dziś możemy tutaj
No bo może
na drugą stronę, żeby nie odstraszyć mieszkańców.
Ktoś by z nami tutaj naprawdę porozmawiał?
Tak,
Może
były
raczej.
przypadki, że jak żeśmy przyjeżdżali, to
Ktoś się zgodził,
też,
no.
tak.
A flagi polskie?
No to jakby tutaj wydaje mi się, że tutaj mieszkańcy po prostu solidaryzują się ze służbami. Dzień dobry, pani zajęta.
Dzień dobry.
Poświęci nam pani chwilkę?
Nie, muszę iść po syna, zaraz przerwa.
Dobrze, dziękujemy. Dzień dobry, przepraszam. Czy byłaby możliwość spytać się pana o kilka rzeczy? No raczej nie. Dobrze,
nie wiem, to co, wracamy już?
Wracamy, tak.
Chyba, tak?
Could you just share with us your thoughts and your experiences?
So, Kasia, as I said earlier, you had this very unique opportunity to see what was happening on the border, because actually it was closed zone, and it was impossible to enter this place for most of people. And could you just share with us your thoughts and your experiences? You are an actress, like from this, Vogue world, let's say, and there you saw another side of life. Could you just share us your story?
Ladies and gentlemen, thank you for inviting me to this discussion. I'm really grateful to be here. I'm a storyteller. I'm an actress, filmmaker. I've been telling stories for more than 25 years now. And every time I was telling every kind of story, I was thinking it was really, truly important. Till what was happening around me was more interesting what I could have done on set, basically. And I started to follow what was going on. So I'm Polish. but I live in Italy. It's been almost 30 years now, although all my family is in Poland. And when the situation on Polish and Belarusian borders started to be on social media, on media, and that was August 2021, I was here and I just read a simple article. Then it followed all the other articles, and that was one thing that really hit me. You know, living here in Italy, and obviously in Italy we're dealing with totally different numbers. The situation, the migration situation, became a part of our life, a normality, unfortunately. But this is the way it is, and yet only 35, more or less, people on some forest on the Belarusian border, on the border of Europe, was a huge news. And it went across. And what was strange and what kind of people were there? And why this is such a big news? You know, I was here and I was watching everything from this point of view. And what really hit me was how easy this situation could have been resolved. Like, obviously, it's just 35 people. It's just 35 people. And obviously, are the families with kids, right? I started to follow the story from the beginning, and I used, I tell you from my perspective, I mean, I'm not a journalist, I'm not a lawyer, I'm not a reporter, I'm not a politician. So how did I get into the point to actually enter the forest zone that no one can and tell the story, and how difficult and dangerous actually it was? But I started questioning, making questions, and there was no answers around. And so I went through from the news, from the reporters, into the social media world, where actually everything is there, because everything is on Facebook, everyone is posting, the activists are posting, the local communities posting, migrants are posting. Everything is there if you want to find an answer or any kind of information. So I started to chat with them. And this is how I enter in contact with activists and people that were living actually in that zone. They were not yet activists. And it was very clear that something not new, but yet very new is happening. So it was like the genesis of something, the beginning. It was the beginning for everyone, the beginning for people to take decision, what to do with the problem, what to do with yourself, where to put yourself in this situation, what is your perspective, on what side of the story you want to be. And that was, as a storyteller, it was very interesting for me to explore. I went there for the first time on November 2021 as a reporter. So I asked my friend, his name is Diego Bianchi, he's a reporter, and he shows and he talks about migrations for, I don't know, all his life. So I proposed him to go to Poland on the border and to use some of my network, let's say, I don't know how to call it. So we went and we did like 50 minutes of reportage for Italian television. When I came back, I thought that the storytelling will change something, right? That this could be a good tool for me to go to media, go to the politicians, go to anyone, to big organizations seeking for help. Obviously, nothing happened. That I'm saying, you know, I'm just a regular person, so maybe knowing you, some of you before, I would have just cut my way into, you know what, nothing will happen. So it took me a few weeks to understand that actually nothing will happen. I was a very mean one. I went to Pier Francesco Maiorino. He went there also to different politicians and to all the organizations I could, and nothing obviously happened. And then I was absolutely personally involved in this situation, and I started to question myself why I'm so obsessed about it from like personal perspective. When I was there for the first time, I got arrested, and it actually right away came to me that if I'm a journalist, my free pass will be easier. If I'm an actress, well, you know, the so-called famous person, I'm safer. If I'm international, which means I'm also Italian, I'm safer. If I take with me another Italian, fully Italian, anything that happens to me, we're safer. So, and another little small thing, if I'm a woman, my intentions will go lost. Like no one can actually read intentions on some actress, you know. So I decided to tell the story, and I didn't know if I was able and how would I do it, but I felt responsible for someone that tells stories in her life. And this story eventually didn't want to be told, and it took me a few months to organize myself to understand how to do it. So without any crew, that was impossible. Most of it I showed with this phone. I did pretend to be a journalist, and this last clip, actually, I went on an official visit. This is what was meant to be the freedom of the press in my country. So it was this official visit on the site where they were building a wall. So I did went as a journalist, and actually it was very difficult to get the permission to do it. And when I got the permission, like the last day I was there, which I asked for a month and a half before sending all the documents, my documents, I thought it was some kind of a trap or a joke, because obviously this is my name. You can just Google me, and I'm not saying that I'm famous. I'm just saying it was very easy to check that this press magazine doesn't exist, and I'm not a journalist. So when I went there on this official guidance around the wall, it was really it was very strange that they actually didn't check anything, and they didn't know. I mean, by them I mean the Guardie di Frontiera, the border, the police border, right? The officers didn't check me, but I was lucky. I was lucky several times. Anyway, why am I saying all this? And I just wanted to say that as a regular filmmaker, I could not do it differently at the time. At the time, there was a red zone. No one could enter, no reporters, not even Pier Francesco Maiorina could get there when he went. No one could get inside, yes. But you know this better than me. So I thought that some of the tools I had in my hand could have been easier, could have been possible. Anyway, what I wanted to tell by this story is to tell it from a little bit different perspective. So I wanted to explore a huge trauma and huge responsibility the regular people that are not activists, that are not lawyers, that are not doctors, that are not politicians have on their shoulders. And this is very, very heavy, and it is a trauma, a true trauma for them. The difference between from a psychological point of view, what is happening in the Mediterranean Sea and what is happening in the Polish-Belarusian border is that up there, most of the people that are dealing with death, dealing with helping another human being are just regular human beings. They're absolutely not prepared for that psychologically, legally, and yet no one else is doing it, so they're doing it. And this brings a huge trauma that will stay with them for years and years, and it brings a huge trauma from the whole region that was cut out of the legality. And, you know, I was born in 1979, just 10 years before the fall of the Berlin Wall. And when I heard that in my country there is a proposal that came very, very fast, because the crisis on the border started in August 21. A few weeks later, there was already a red zone. And a few months after, there was already a proposal for a wall. So they started to build the wall on January 22, and that was only 1 month before the war in Ukraine. And it was just very, you know, it was just very little people were passing through that border, and there was a lot of military, a lot of police, a lot of press, a lot of things, a lot of talking, a lot of storytelling about how dangerous this European border is and how necessary is that wall. So the wall was built, the people are still crossing, the trauma continues, and just the story just doesn't stick the reality. It's just too little people. It's just too little people. And but the trauma is huge. And another thing I wanted to concentrate my point of view on this trauma, trying to find answers in the past. I'm Polish, and my grandmother lives in Łódź, on the rubbles of ex-ghetto, Litzmannstadt ghetto. That was one of the biggest ghettos. And she lives just in front of the little wall. And this wall is a wall of the cemetery of the Jewish ghetto. She lives there since 78. And she doesn't know anything about the ghetto. She just doesn't care, like most of the people. People don't ask questions, because they don't want answers, because the reality is probably too heavy. And my grandmother is also in this documentary, because I wanted to ask her why we never talked about it, why she never questioned where was the ghetto, why she never questioned herself. And she just said, well, I didn't, because it doesn't, well, you know, probably if I knew, I wouldn't be in this house. But you know what, does not matter, because life goes on. After I will die one day, after me there will be another, you know, family living in this house. Who cares? And my grandmother is a very sensible person. This little thing, what I'm saying is that obviously life goes on, right? Obviously the memory, we reject what is too strong, and our history, Polish European history, is so difficult to digest, and obviously we haven't digested yet. So I think that when I heard that there will be a wall in my country, something just clicked in my head, some kind of, it was not only, you know, to be not right with it. It was something from the physical and psychological level, some kind of a trauma. And I'm not Jewish. I just lived in a place when there was a ghetto, so in front of some wall, and I am a daughter of this other wall, and there's this new wall coming up, and there is one thing that is more connected with your story. One of my friends, one of my dear friends is Zera Dogan. She's a Kurdish artist, which spent 2 years and 9 months in a Turkish prison for terrorists, because she painted a picture that showed the destruction of Muzaybin by Turkish army. And she spent 2 years and 9 months, and she became kind of famous because Banksy, he made a murales in New York, in Soho, with it was written "Free Zera Dog," and she was still in the prison. Anyway, eventually I met her so when she was in, and then after she finished her permanency in prison, we met in Rome. And she was one of the first people which I showed this documentary, and I asked her to paint the poster. The poster. I always thought she would be the best person to do it. And she told me that the point of view of from our perspective, which is not people on the first line of what is happening, not even activists, not refugees, not migrants, just regular people that are still questioning or maybe doing something with it. She never thought about it. She never thought that helping other people, so making this choice one day, waking up and saying, that's it. I cannot stand to read newspapers. I have to do something. And then taking a huge backpack, going to the forest, finding yourself in front of a child that is seeking for help. And the only thing you can do is, in the best way, is to give him a soup. And then you have to leave this child in the forest, and you have to go back to your family and put your kids in the bed. And the next day is the birthday of your daughter, and then you have, it's this huge trauma on having a burden, having this responsibility for another human life. It is something that I wanted to tell in this documentary. There is no refugees in my documentary, and that was a specific choice because I wanted to put a focus on just regular people that live close to the border, and they have to make their personal choice.
Thank you very much, Kasia. It's also very emotional, and it's difficult to digest all this information. And like you said, we have problems with digesting our history, but actually, at the very moment now, there are some people who it wasn't their choice actually to abandon their life and to flee. Like Orhan said, it's extremely difficult decision to leave your country with your family, or even leave your family and find your place somewhere else. It's always incredibly difficult decision. So at the very moment, there are people also on the Belarus border and also on the Mediterranean Sea who are looking for new life, and this people is going to be more and more and more each year, and we have to do something about it. Thank you very much. Sarah. We still have one. Oh, okay, so maybe we can, and it is accessible, right, on the Canal Plus? Canal Plus?
Or
Yeah, in Poland.
Italy?
Yes, in Poland, it's in. It was a whole funny thing because obviously I didn't found any partner, any distributor in my country, which is Poland, and luckily that this documentary won as the best documentary in Italy. Now is concurring for another big. So it was a big thing in Italy, but very difficult to distribute in Poland. But after the change of the government, something happened. I see something happen. So now the Canal Plus in Poland took it, so luckily. And then I went with the documentary for 10 days with activists to show the documentary. And what was from right away, what was very strange, not strange, I mean, it's nothing new, but it is really incredible how with all the access to any kind of information we have, and that's for free. Till this is free, that you can, Google, we are free. Though, yet people, they don't know. And even people close to the border, in Poland, I was checking what was happening more to the center, more to the, to the German border, what is happening in Europe. People just don't know. They don't know. And this is incredible that this is so easy to access for everything, and everything is there, but probably we're not able to deal with how to choose what we want to know. They don't want to, yes, it's a very difficult, yeah, they don't want to. Like, it is obviously easier to, it's not nice, it is easier to choose one kind of a story, because the truth, if you really see the truth, then you have to live with it. And it's so difficult. Like me, psychologically, I'm not ready. Psychologically, I can say I am not strong enough. And I don't even want to have this responsibility. But once you know, once you know, you have a responsibility. This is the thing today. It's not only about knowing, it's, when the world knew about from the newspapers that there were campi di sterminio, the concentration camps, and this came out from the newspapers, yes? So the one day they woke up and they saw the horror. Now they know. Now you can see the horror whenever you want. So what do you choose? Not to see it. Because it's just too overwhelming. Like your story in a short amount of time, and you made it really, really short, right? Yeah. Obviously, it's just, you just went by points. I can't even get there to the first point, But I just think, me as a storyteller, I have this responsibility. You taking responsibility, you go around and you tell your stories. And I think what you all do, it's so incredibly important. And this is the story of our times. And I think one day our grandchildren will ask us, where were you? What have you done with all these informations? Because certainly we cannot say we didn't know. And that's enough for me.
się ruszają, tutaj coś stoi, pewnie się mogę. Ciszej. Boicie się, na.
Co to jest za numer?
To
Jakoś
Coś się ruszało.
jak się ruszamy, to pewnie coś stoi metalicznego.
No właśnie. Co to jest za numer?
Do pogotowia antyrepresyjnego, czyli prawników, którzy nam pomagają, jeżeli trafiamy na pały.
Okej.
24H.
Czuję się bezpieczniej.
Non saranno delle conclusioni, è stata una giornata molto impegnativa e potremmo concludere con queste emozioni che abbiamo ricevuto dall'ultima sessione. Però quindi le mie brevissime considerazioni non hanno certamente la pretesa di riassumere non saranno delle conclusioni, è stata una giornata molto impegnativa.
So it's time for conclusions. It's been a long day, so we might just we can just conclude with the emotions that we felt during the last session. In short, some considerations that do not want to summarize the debate and the speeches that we have hosted here today, but I want to thank all the speakers for their precious contributions, because they helped us thinking, assessing and feeling everything they talked about. So we will try and assess and think about these speeches again. And I think that today's conference has given us an idea of how complex the challenge of migration and the challenges of migrations are. And today's conference also taught us that challenges must be faced with a long range vision, with a look at the future. So I would like to thank all of the speakers that gave us all of this today, with a capacity of vision, analysis, understanding of what migration is all about today. I must also say that we have got much food for thought in order to give the right weight to the different situations and realities. We gain knowledge, and when we talk about migration today, we need knowledge to contrast what is happening. We also, and especially to contrast an approach based on fear, where the inability to make the right choices is also hidden. Fear, refusal are just feelings that have become a strong weapon for nationalisms. The society that they have in mind is not based on equality, but it is based on a new concept of identity. And this dangerous weapon is not considered to be as it is, but it helps us understand the stereotypes and the biases that we are now facing, as Professor Ambrosini has told us. We should also be aware that migration is our history. It's part of our history, and it's a history that keeps going on. So renouncing, giving up on a more ambitious migration project means going towards failing in managing migratory flows. And real data tell us that the world cannot now go on without migrants. You have heard today many things that ask us to rethink the migration policies, to think about integration, right of labor, right of employment, regular migration, and in general integration. So all of this has required, of course, political choices. And after today's conference, it's important for us to have this vision for the implementation of the new European Pact, with the need, on the one hand, to share views and to face criticalities and challenges. There is a risk of making choices, regressive choices, and there are limitations some limitations of these challenges, as the European movement has told us. So we need a new cooperation plan with countries such as Africa, with continents such as Africa, and in Europe we have some war scenarios. But within this context, we need to create some safe lines, and there are some tools, legal tools, that must be appropriately used by looking at the principles of international covenants, of international constitutions. Our exchange of views today has focused on the asylum system and on everything that has been done, and as well as on the possible consequences of delocalization and other policies we have talked about. We also exchange views with lawyers and with the academic world. Judges must become the impartial, unbiased guarantors and protectors of rights. As we have seen today, this role of protectors, of guardians of rights is not easy, because it's full of challenges and traps. Judges need to protect rights, but this is also a hurdle of political choices concerning migration phenomena. So I would like to thank Sara, but also Eduardo, for their fundamental contributions that have given us and that gave to the event. So for the last session, I would like to thank all of those who witnessed their commitment not to accept what is happening around us. The last speakers also provided the numbers describing this strategy, so they witnessed a tragedy that asks us to be caring and to support all of those who every day provide a helpline for those refugees and migrants and help them integrate into small realities. Thank you, Kasias Muniak, for giving us your testimony. And I would like especially to thank Orhan Karabakak, who told us his personal experience, and with his personal experience he also witnessed the history, the story of many people who are now in prison because they fought for democracy and rights with courage. So I would like to mention again the president of Assab that is President Murat that is still detainee. His history reminds us, his story reminds us that we can all become refugees overnight. Horan's story reminds us of the fact that we have the duty to hope. I would like to conclude with these words. Emiliana Baldoni and Giampiero della Zuanna wrote these words: migrations are an arrow within the arch of the human species. And in our mad world, they might represent the solution and not the problem. Thank you.